Yeah. Okay, hello and welcome everybody. Warm welcome from the Single Resolution Board and the European Banking Institute. It's great to welcome so many of you to today's conference on bank resolution. My name is Georg Ringe. I'm a professor of law and finance at the University of Hamburg and a board member of the European Banking Institute, and it's my pleasure today to moderate this conference. This is already the second conference, a joint venture between the Single Resolution Board and the European Banking Institute. Unfortunately, due to unexpected circumstances, this has to be online. We would have loved to be together, of course, but on the upside, it's fantastic to have so many people joining in online from all parts of Europe and indeed from the world. So it has some upsides as well, I guess. Now, bank resolution is one of the key interests of the European Banking Institute, and we have a number of interesting subjects put together for today's program. I'll explain the agenda a bit later. Just to remind everybody that the event will be recorded, and you should have received a reminder of the data protection notice ahead of the event in the invitation. But for now, I stop chatting and hand over the word to the chair of the Single Resolution Board, Dr. Elke König, for a quick welcome. Elke, it's wonderful to have you with us, and thank you so much for addressing the audience.
Thank you, Georg, and a warm welcome from my side too. Thank you also. I see Thomas as the guardian of the European Banking Institute and one of the ones who is always able to convince me everyone to participate. A big welcome, a big thank you to that. Good afternoon, or well, no, it's good afternoon, ladies and gentlemen, and in particular, thank you and good afternoon to the speakers of this conference. I think you've already said, Georg, last time we were at least partially in a real session, in-person session for this event. This time, unfortunately, it has to be all remote. So I first keep my fingers crossed that technology works fine and smooth. And ideally hope that with the rollout of the vaccination, the next event will be again in person, or at least I see everyone three-dimensional and not just as little pictures on a screen. With that, let me just try to give a bit I would call it my expectation for the event and perhaps ideas. I think it's fair to say that we have gone a long way when we look at banking supervision and bank resolution. We might have definitely failed the test laid out for us during the financial crash in 27-28. I think that's a fair statement. But we have since dusted ourselves down and picked ourselves up, or to put it the other way around, we have put in place structures such as the SSM and the SRB, and we have worked hard on enhancing the quality of bank balance sheets. And when I say we, it includes, of course, also the industry. And we've had a lot of academic thought going into this, which got us into a situation where this time during the crisis, we see the banking industry in principle as part of the solution and not at the center of the problem. I think there is still, nevertheless, a lot to be done. And for that, I'm very grateful for the cooperation between the SRB and the European Banking Institute, that you have probably addressed all the topics that are close to my heart during this one afternoon. So I'm expecting everything is sorted out, and if everyone listens carefully, we have the solution as of tomorrow. To be clear, we have always said that harmonizing bank liquidation law is centerpiece. We have a bank resolution regime for Europe, and it is confronted, or it is based on 27, I think there are even more different bank liquidation laws in the union, including the fact that what means failing or likely to fail does not immediately potentially trigger an insolvency. So I'm very much looking forward to listening in and to hear your ideas here, because I think it's one of the parts that is core, or it's at the center point for a true capital market union, for EDIS and the like. So just my expectations are sky high. Second panel, post-Brexit world. I think, again, cooperation, coordination between authorities was always important, stays important, and I think we need to find a very clear system around. London is still the financial hub, and we need to cooperate. At the same time, we need to be sure that for the European Union, we have clear answers and clear understanding. So probably the importance can't be understated. The third panel is one which I think has probably very different expectations from both sides. Home host balance is nicely set, and I'm always struggling when we deal with banks within the banking union, and someone says, I'm the country, you are the host country. Well, the ECB is the supervisor, the SRB is the resolution authority. Isn't it all home? Or where is the issue of home host? Now, I'm not underplaying it, and I think we need to be also fair to say that this is really a crucial issue within our resolution consideration, including the fact that when you compare BRRD1, SRMR1 with the banking package, BRRD2, SRMR2, then I think you might be provocative in saying, have we taken a step in the wrong direction? Have we more added safeguards for host countries than really focusing on the banking union? It's at least, I try to be provocative. At the same time, of course, we have to balance the legitimate concerns of all member states, and which means you need to balance it without ring fencing. So you need to ensure that all resolution consideration are really solidly implementable. It's a difficult topic, and it's in particular a very political topic, I think, to be considered. NPLs, not much to be said, except that clearly you don't need to be a rocket scientist to say that with the prolonged lockdowns in some areas, NPLs will substantially increase. And I've always a very practical advice here. The sooner you deal with a problem, the better. So sufficient provisioning has never harmed, and trying to find answers. If you try to find answers, then at least you also need to say, there is no miracle solution how to make potential losses go away. And if you talk about, for example, bad banks and the like, fine, but then clarify who is financing what in this context. And the last one, your last panel just made me really pause, because I think we all try to cheer ourselves up in saying that COVID is somehow a black swan. Now I read here, what are we doing with future white swan events? So I think you're right. We need to address the topic, but I would definitely be interested to get the ideas around this. So with all of this, I don't want to front run the panels. I'm anyhow talking a bit too long. I would just like to nevertheless end again with a positive note. I think we have a lot of obstacles to address in the European financial framework. We have a lot of topics. For some, I have stopped counting how many roadmaps we have prepared. Now we need to hit the road somehow. But I think one thing is pretty clear. We are in a far better position than we've been 10 years ago, or even 5 years ago. And we have a very clear message, at least, and a clear mission, at least from a resolution perspective, and that's to protect the general taxpayer and to ensure financial stability within the system. And with this, I would just finish with a big thank you to all those that are participating. I know that we have a large number of people listening that are definitely more interested in your academic research than in my opening remarks. And with that, I will stop. Thank you again. I hand the floor back to Georg, and just for all of you, please stay safe. Bitte bleiben Sie alle gesund.
Thank you so much, Elke, for your very kind words, and giving us your thoughts on the program. I very much look forward to discussion actually whether COVID is actually a black swan or whether it isn't rather a white swan. But that, I guess, is something that we can discuss later on. Thanks so much. I now give the word to Thomas Gstettner, who is the president of the supervisory board of the European Banking Institute, for his welcoming statement. Thomas.
Thanks so much, Georg, and also a great thanks to Elke for her opening remarks, and also for being such a big supporter of the EBI. And also, obviously, I thank you for making possible that we have this second conference again together with the SRB. Let me also welcome a few other people in the audience, which is now more than 300 people I see now in the participant list. So very well participation rate. First of all, welcome to Christos Skortsos, who's the president of the academic board. And obviously also to you, Georg Ringe, welcome. And thanks so much that you and Christos organized as the key or lead academics this conference together with the SRB. You both are leading the work stream of the EBI on financial resolution. So you're essentially the key go-to people when it comes to this conference. And thanks again for organizing this. Yeah. Another welcome also to Enrico Leone, who is the Chancellor of the EBI, and also obviously to all the speakers of this conference, the ones from the SRB and all the academics. Most of them are affiliated with the EBI, and also all the other speakers who Georg will introduce later on in a bit more detail. I'm very happy that we're having now this second conference taking place with the SRB. And for me, this shows also the growing recognition of the EBI as a European research institute in the area of banking. In 2016, we started with 6 member universities, and now we have 35 universities being member of the EBI. But the EBI in this regard has come very far. For our academic research activity, obviously, the 35 member universities are crucial and our key pillar. But banking research or research in banking-related matters can draw a lot of input from being challenged by practitioners in the public sector and in the private sector. That's why EBI is linked to public authorities like the ECB, like the ESM, the Commission, but also obviously links to the SRB, organizing joint conferences, having discussions with policymakers, like in our policy conference, is another second key strength of the EBI. Let me also mention another point. The EBI is a European institution, but its members are national academic universities in all European countries. As such, the EBI is able to provide academic expertise in the area of law and economics in banking-related topics from a European and a national perspective in most European countries. The area of banking regulation, banking supervision, and banking resolution are always a combination of national and European laws. And I think the topics, and in particular the first topic of today's conference, is highlighting this a lot. It deals with the harmonization of EU bank liquidation laws. In the Eurozone, bank resolution happens according to the BRRD if there is a public interest in resolving the respective bank. In this case, and this is related to the Eurozone, the SRB will action the necessary steps to resolve a bank. However, many banks are now in such a shape that their failure would not endanger financial stability and that they can be liquidated if they fail through regular national insolvency proceedings. And Elke König once said, the extra safety net of resolution through the SRB is only for the few and not for the many. And I think it shows very clearly how the whole thing is distinguished. I mean, we have around about, let's say, 5,000 banks in the EU or in 3,000 in the Eurozone, and more or less 150 probably would fall within the remit of the SRB. But within this limit, not all of them would be, if there would be such a case, be liquidated according to the BRRD and the SRM. And if there's no public interest, national insolvency proceedings apply, like for any other business, in the EU. And this means, obviously, a great variety of national insolvency proceedings in the EU. To put it very simple, in what is generally called a banking union in the Eurozone, banks can be liquidated according to 20 different regimes, the BRRD, and 19 different insolvency regimes. And this can obviously lead to very different outcomes. Yeah? And this is not legal theory, it's quite practical, I have to say. We've seen that a bank can be declared as failing or likely to fail with no public interest for resolution by the SRB existing, and then national insolvency laws apply. And the national insolvency law, and Elke König has put this very clearly also beforehand, sometimes have a different standard as to what insolvency means if compared to the standard for a failure or likely to fail decision under the BRRD. We have had such a case in the Eurozone, and actually I was very happy that in my main job in ECB, I was able to work with Elke König on this particular case, and the outcome when it first arose was very surprising for many of us, yeah, that there's a difference between the two different standards of failing or likely to fail and a national insolvency regime. And this example also shows there's a further need for harmonization of EU liquidation laws in the EU. This is another requirement for creating a real banking union in the Eurozone. Also, the other topics of today's conference on standard setting in a post-Brexit world, cross-border resolution, and tackling non-performing loans are extremely up to date. In relation to the last topic, I have to say, unfortunately, because the banks in the Eurozone have made quite significant progress in reducing their NPLs in the last years. And now, due to the COVID-19 crisis, obviously, we will see again another increase of NPLs with European banks. I think the EBI, because of its pan-European approach, can provide material input to the current debate on all of these topics. Therefore, a big thank you to the SRB again, in particular to Elke König and her team, and the academics of the EBI for making this conference possible, and that we can discuss all of these topics in a bit more detail. I wish you a very interesting afternoon and hand over now to Georg Ringer, who together with Christos Skortsos will lead you through this conference today, and I thank for your attention.
Thank you so much, Thomas. That was terrific. I now want to introduce the day or half day ahead of us. Just for everybody's benefit, I think the major idea of this type of conference is to bring academic research and practical experiences together. So bring academics and policymakers together and practitioners, and produce some fruitful cooperation between those different worlds. So in that spirit, I hope that we'll all participate in a good discussion, and there is ample time for interaction for all of you in the audience. The agenda today is really an attempt to take stake of resolution, what is going on at the moment, how to make it work. It's been born out of the crisis 10, 12 years ago, and now we do have had some time to make it work. But there are new challenges that are rising all the time. Just think of Brexit and COVID. And in that spirit, we've put together a number of interesting subjects. We've already heard from our two chairs. We're going to look at the harmonization of liquidation laws, an important policy issue. We're going to look at Brexit and the consequences for resolution, and more broadly speaking, the home host country conflict that may jeopardize the success of resolution. And finally, the perennial issue of non-performing loans and how that may affect the success or non-success of resolution. To conclude the day, we'll have an exciting panel debate on COVID, the white swan risk, so not the black swan, but the white swan risk, and the lessons for lawmaking. So are we properly taking into account such risk when we write law? So I think this will be a broader policy concern, and hopefully we'll have some interaction there with all of you in the audience. That brings me to the format. In all the sessions, we'll have 20 minutes allocated for the speaker, 10 minutes for the discussant, and then we have about 15 minutes time for general Q&A. And I would like everybody please to respect those times. For the audience, you will be able to ask questions using the chat function, and I will try to moderate and give the word to you if you would like to ask the question personally, If not, I'll read it out. But please do make use of the chat function even during the presentation and afterwards, of course, as well. That's it. I now come to start our first session, which is dedicated to investigating the case for harmonizing EU bank liquidation laws. And our first speaker is Christos Hadjimanuel, who is a professor of monetary and financial institutions at the University of Piraeus, a visiting professor of law at the London School of Economics, and most recently now a member of the Monetary Policy Council in the Bank of Greece. And of course, he is an active member of the European Banking Institute, so we very much look forward to your presentation. The discussant will be Jan Reinder de Carpentier, the Vice Chair of the Single Resolution Board. Over to you, Christos. We look forward to having your thoughts.
Thank you so much, Georg. Many thanks to the SRB for providing this opportunity for me to address this audience. Ladies and gentlemen, I'm thrilled to participate in this discussion. Indeed, I'm thrilled to be able to address this particular issue, which is very close to my heart and on which I've worked for some 20 years now. Okay. I'm sorry, let me make sure that I control this. Can we move to the next slide? Fair enough. The slides, well, I will not go through all the details. They provide much greater detail that I would like to cover in my remarks, in my oral remarks, but you may later on find it on the EBI website if you are interested. Now, the basic idea is the following. The BRRD is already in operation for a number of years now, and for 5 years, the bail-in mechanism is up and running, is the supposed default position for banks that need to be resolved. For the rest, which are the great majority of banks in the Union, liquidation should take place under national legal provisions. Now, the fact of the matter is that the BRRD regime was produced at a time when the euro area was in crisis, when fiscal concerns were the key consideration, where the peripheral countries were facing very severe problems due to the bank's overhanging. And I think that the end result shows the marks of its time. And I think that this is not for the better, this is for the worse. Over the 5 years in which the system has been in operation, we have seen that it does not work according to plan. What do I mean? Well, there has been a very strong reluctance either to place banks in resolution rather than sending them to liquidation, or using the bail-in as the strategy for resolving banks that go in resolution. We have seen in the case of the Veneto banks that banks that were expected to go in resolution have been sent to national liquidation. We have seen in the case of Banco Popular that bail-in was not applied. Instead, the sale of business arrangement was preferred at the last moment. We have also seen that the technical operation of the rules has not been fully satisfactory, either because the interface between the failing or likely to fail decision and the decisions, A, to place a bank in liquidation under national law, possibly before a national judge, as in the case of the Latvian bank in Luxembourg. or the decision of the supervisor to withdraw the license following a finding of failing or likely to fail does not work perfectly well. Now, there is a new provision in the BRRD which may partially resolve this problem, but the problem of coherence of the supervisory, liquidation, and resolution processes is still open. And then again, we have seen liquidation not to be true liquidation. The text of the BRRD, in fact, the preamble talks about liquidation under normal insolvency proceedings. Liquidation under normal insolvency proceedings does not mean just any kind of insolvency proceedings. It should imply piecemeal liquidation as distinct from restructuring or some sort of reorganization. Nonetheless, we have seen in the case of the Veneto banks, I don't blame the Italian system. I'm in favor of it, but we have seen that liquidation was interpreted as insolvency proceedings at large, of any form, and even with the benefit of state aid in liquidation. Now, could we move to the next slide, please? Now, the fact of the matter is that these problems have been taken cognizance of. The German presidency must be congratulated. The Commission must be congratulated for the fact that they have not obstinately kept to the existing policy, but have opened the debate and have pursued new solutions, and that within a spate of 6 months, effectively, or 7 months, from January through, from June 2020 through January 2021, they have managed to produce very substantial ideas and to identify points of convergence between the member states. Last week, the Commission published a consultation document asking 39 very pertinent questions on the fate of the bank crisis management framework, and we expect draft legislation to be produced by October 2021. This is most welcome, and even the general tenor of the discussion is most welcome. Consensus appears to be building in the direction of moving towards a harmonized, if not unified, system of bank insolvency law. I'm talking about insolvency as distinct from resolution. There is remarkable convergence around the idea that liquidation should take advantage of the P&A tool, of a sale of business-like tool already used extensively in the United States, P&A standing for purchase and assumption, which is the preferred form of addressing failed institutions in the United States in the hands of the Federal Deposit Insurance Corporation. There are still many points of dispute, including the role of state aid in liquidation. Not remarkably, but not surprisingly, the disputes revolve around the insolvency financing question and the taxpayers or the banking industry's involvement in underwriting the cost of bank failure management. If we would move to the next slide. Turning specifically to the distinction between resolution and liquidation, but that was already mentioned by all previous speakers, I have to say that the dichotomy is unjustifiable. It is unjustifiable for a very simple reason. There are not only two options, there are more options. In fact, there is a continuum of options that should be taken consideration of. What do I mean? The assumption in the BRRD is that you either have a resolution process for systemically important banks, whereby the bank is restructured or partially restructured so that the bulk of its operations is kept intact on grounds of systemic stability, or if the public interest test, meaning systemic stability issues, cannot be identified, the bank is put in liquidation. And liquidation here suggests, as I've mentioned before, piecemeal liquidation, that is collection of assets and distribution to creditors of the proceeds from the liquidation process, as in a typical corporate liquidation set of proceedings. However, there is a clear third possibility that has not been taken advantage of, namely the equivalent of insolvency proceedings in national law, allowing not only for simple piecemeal liquidation, but for alternatives to piecemeal liquidation in the form of preservation of the business, whether through reorganization proceedings or through liquidation proceedings which involve a sale of business. The difference here being that in most cases, in general corporate insolvency, when we sell a business, we mean that we sell the assets of the business, the operating assets of the business, the inventory, the machinery, these sort of things. In a bank, however, this doesn't work for evident reasons. A bank operationally is a single unit. Assets and liabilities go together. For the bank to be able to survive as an operating unit, regardless of what happens to the legal person, to the cell, to the corporate cell of the bank, you require to preserve and potentially transfer both the assets and the liabilities. And this is something that was realized long ago in the documents that were first produced on this subject by the Basel Committee and by the IMF. Both institutions worked in the early notice in order to produce documents, and the BCBS produced the weak bank reports, and the IMF produced the Global Bank Insolvency Initiative together with the World Bank. It produced this document. Unfortunately, this was only published with many years of delay in 2009, by which time we had the fully fledged global financial crisis. If we could move to the next slide, please. I have to admit that I am not impartial here, because I was one of the people who drafted the second document. At that time, state aid was not the primary concern, and in fact, bail-in was not on the table. It did not exist. But what we perceived back then was that you need a special resolution regime for banks, regardless of whether they are of systemic importance or not, for two very simple reasons. It is good for the health of the banking system to have orderly liquidation. Accordingly, to put a bank at rest without causing hiccups for depositors or borrowers, because of course the bank has an important function as a lender too. And then again, it was evident that you need special American style, P&A style transactions in order to maximize value, even without any state aid, for a very simple reason, because this is the best way of liquidating. It is for the benefit of creditors. It maximizes estate value. Accordingly, even in pure insolvency proceedings, it is useful to have special tools and special arrangements for banks. If we could move to the next slide, please. Accordingly, my view is that it would be much preferable for the European regime, especially now that everybody recognizes the need for harmonized liquidation proceedings to have not two streams, a resolution stream for the few, a liquidation stream for the many, even a harmonized one, but to have a single stream crisis management proceedings for all banks. The only difference being that depending on the circumstances and the systemic significance of particular banks, you will need to utilize different tools or to utilize the same tools potentially with the support of the SRF or of other resolution funds in non-participating member states. If you do not have systemic concerns, you should nonetheless be able to use all the other tools available in a resolution process. There is absolutely no reason for which technically superior and value maximizing tools should not be available in all circumstances for all banks. Can we move to the next slide, if you would? This would involve essentially to think carefully about the general trigger which would bring any single institution to this insolvency resolution stream. But even if my proposal would not be taken up, even if you would have separate liquidation and resolution proceedings, you would still need to redefine the triggers and to make sure that failing or likely to fail, which is the trigger for both streams, should be fully aligned with the grounds for insolvency, for the liquidation process per se, and for the withdrawal of the bank's license. Beyond that, I believe that if we would follow the single stream proposal, the PEA, the public interest assessment, could acquire its proper role. Its proper role is to trigger, if need be, an intervention, including the use of outside of external funds. External funds in this particular case being activation of the SRF, activation of the public stabilization tools. If there is no need for external support, if the whole process can be dealt with financial resources that are internal to the institution or that would be expended anyhow, as for instance, the funds that would be provided by the deposit insurance regime anyhow, even on a piecemeal liquidation, because of course certain depositors are covered, then there is absolutely no reason to use the public interest test in order to differentiate. So I think that the proper role for the public interest test, which should be revamped, is to decide whether external resources should be expended in facilitating the orderly exit or continuation of an institution. Which brings me to the liquidation tools, and specifically to the P&A, it's on the next slide, on the role that FDIC-style P&As could play. As I've mentioned before, there is now general agreement on the idea that P&As would be a significant step forward. I don't think that there is any member state or any institution or agency that disagrees on the basic premise. The main question is whether this should be framed differently from the existing sale of business tool, which is available currently only in case of resolution. My firm belief is that for reasons of administrative expediency, effectiveness, also in order to avoid a differential treatment of very similar cases and the possibility of arbitrage between the resolution and liquidation regime, even with a dual stream solution, that is, with separate proceedings in place, the same tool should be available on the same grounds and in the same form in both cases, which means that rather than going for a separate P&A tool, we should simply revamp the existing sale of business tool. But beyond that, why shouldn't we be able to use the other resolution tools in liquidation too? What is there to suggest that in certain cases it should be completely impossible to resort to any other resolution tool? Okay, a couple of minutes. And my main point here is that you'll hear in a short while people talking about the use of asset management companies as a potential solution to the COVID Npls. Well, we already have the asset separation tool, we already have a framework in the resolution scheme. Why shouldn't we use it for that too? Let's move, if you don't mind, directly to the financing question, and let me conclude with that. DGS financial assistance. Today, the utilization of DGS funds in liquidation is prescribed in the form of payout of covered deposits, but there is also a national discretion to use it for restructuring purposes too, the so-called alternative measures. Of course, if we go down the P&A path, it should also be available to support a P&A transaction on least cost grounds, but here it has to be observed that the least cost criterion is very ill defined in the present regime and definitely needs to be rethought. If we could move to the next slide, which means that we need to think very properly, and we think to have a European solution, a pan-European uniform solution to how we compare the counterfactual of a payout by the DGS of covered deposits to the use of DGS money in liquidation or in resolution. And here I think that Denmark points in the right direction because it includes in the counterfactual scenario, it takes into account a liquidation discount. External costs, should they be included in the calculation or not when you consider what would be the counterfactual? But then again, we need to think very carefully about the basis for determining what is the cost for the DGS in participating and supporting NP&A transactions. Should we look to the cash flow cost, that is the out-of-pocket upfront money used, or should we think about the final net cost at the end of the resolution or liquidation process? It would make for very different calculations and would yield very different results. Finally, 2 slides, the following one, please. Let me be very clear about a point. There are other points, but let me just conclude with that, the most controversial point of my presentation. State aid, the perennial issue. I do not have a dispute with those who say that the same criteria should apply for state aid in resolution and in liquidation. What they mean, however, is that the same minimum threshold of bail-in, the famous 8% bail-in, 8% of the total book value of the bank bail-in, should happen before external financing should be made available in support of banking institutions. Let me say that I think that this is a totally misconceived idea. It is totally misconceived because if we are talking about DGS funds would be expended anyhow even in liquidation, because the activation of DGS funds is completely unrelated to the existence of bail-in, resolution, or liquidation, or any other debate and consideration, simply because it operates automatically under a separate instrument, the Deposit Guarantee Schemes Directive, and not under the BRRD. But then again, let's think for a moment about state aid in liquidation and resolution regardless. It's the final point, Georg. I conclude with that. When you expend resolution fund money, or when a state intervenes, it intervenes in order to safeguard the financial system. Why should we take the risk and the cost to the financial system? Simply because the 8% minimum minimum bail-in has not been reached. This is irrational. If shareholders have already been wiped out, if junior bondholders have already been wiped out, why shouldn't we use public money? There is no moral hazard. Why shouldn't we simply use public money as necessary in order to stabilize the financial system? If the decision is taken at the European level by the SRB and not by national governments, there should be no dispute about that. Thank you so much.
Thank you, Christos, for this extremely rich and thoughtful, very, very clear presentation with making a number of very straightforward points, and I'm looking forward to the discussion. But before we get to that, let me give the word to your main discussant, Jan Reinde de Carpentier, SRB Vice Chair. Floor yours.
Thank you, Georg, and good afternoon, ladies and gentlemen. First of all, thank you very much, all the participants and speakers, for joining us at the second EBI SRB conference on bank resolution. Also, special thanks to Christos for his presentation, which raises some very interesting points for further discussion. I would like to start by saying that I share some of the criticism to the existing framework that Christos mentioned. We are aware of some issues to be addressed, such as the possible limbo situation, the divergence across the national insolvency procedures, and the inconsistency between the BRRD and the Commission 13 state aid communication. However, I cannot share the general criticism of the framework. I think that the system is fit for purpose. It does not require a major overhaul. Since it is in place, it has been able to fulfill its main goals. This does not mean it is perfect, as I just have said. This is why we are looking forward to contributing to the public consultation on the review of the crisis management and deposit insurance framework launched by the Commission some days ago. This is also why we continue to call for the completion of the framework as envisaged. I will now turn to some of the more specific points highlighted by Christos. First, the contradiction between resolution and liquidation. One of the key roles of the SRB is to ensure financial stability. The resolution plan for almost all banks under the SRB remit is resolution and not insolvency. Almost all banks under SRB's direct remit are eligible for resolution, since they are all likely to meet the public interest assessment in line with the EU resolution framework. Therefore, the SRB expects and plans for the use of resolution tools for such banks. Christos states that all banks should be subject to the same regime. However, the logic for the PIA, and therefore a different regime for the largest banks, is in my view a rather simple one. The largest banks in each member state, when getting into trouble, can create problems across Europe. So they should be managed at EU level. Many of them are active cross-border in Europe or internationally. This discussion around the contradiction between resolution and insolvency is, in addition, closely related to the criticism Christos makes to the public interest assessment. Christos proposes that the PIA is used for the justification of external financial assistance. The PIA is, however, the gateway for resolution, because the extraordinary powers granted to the SRB could crash with constitutional property rights. Therefore, their use must be proportional and adequate, justified by a public good such as financial stability. Still, we are revising the PIA. The SRB is expanding its analysis underpinning the PIA against the 5 resolution objectives and expects to deliver its updated approach within the next resolution cycle. In particular, the SRB is currently working in cooperation with the national resolution authorities to deepen the analysis on the impact of system-wide events, and other aspects will follow at a later stage. Second, I concur with Chris's call to solve the limbo problem, which requires aligning the failing or likely to fail declaration with the triggers for national insolvency, so we're not ending up somewhere in between. This is essential to make the system work properly. Third, we definitely need to harmonize, or at least achieve further convergence in the national liquidation proceedings. This is one of the main existing hurdles for resolvability. At the moment, we have 21 plus different insolvency frameworks in the banking union. This leads to a broad range of issues, for instance, related to the assessment of the no creditor worse off principle and level playing field concerns. Clearly, the lack of a harmonized EU liquidation regime is a major obstacle towards a fully fledged banking union. Bank insolvency procedures should be subject to common standards and practices. Fourth, closely related to my previous points, a harmonized European liquidation regime would solve some of the shortcomings that I just mentioned. Chris has mentioned that the general liquidation framework is highly inappropriate for banking institutions. I concur that the current situation is not ideal. The end goal should be to put in place an EU liquidation regime alongside an EU resolution regime, something that looks like a European FDIC. However, we understand very well how hard it is to harmonize national insolvency laws, which are very much embedded in national legal frameworks. Therefore, we can favor a stepwise approach as a more pragmatic solution. Targeted harmonization focused on key elements of bank liquidation should not be further delayed. Fifth, we must look at how that liquidation regime would be financed. That leads me to one of the key aspects of Chris's presentation, which is the use of EDIS, DGS, in resolution. We have several resolution tools which allow us to react to different crisis scenarios. Sale of business and asset separation tools might be best suited for small and medium-sized banks. Without any doubt, EDIS is the main missing aspect of our banking union, and this is closely related to these transfer strategies. Further use of EDIS in resolution to fund such transfer strategies would allow reducing the overall cost of banking failures. It is a major aspect of the solution to address the challenges around the failures of those banks. As Chris stressed, this requires reconsidering some elements of our framework. The least cost test, as is currently foreseen, makes it extremely hard to use funds from deposit guarantee schemes in resolution. This endangers the successful use of these transfer strategies due to a lack of funding. Therefore, the least cost test should be amended in parallel with the entry into force of EDIS. Revising the super priority of deposits and including measurable indirect costs, as Christus recommends, could help in this regard. It is, however, important that there would be clear thresholds for these indirect costs based on objective criteria. Importantly, any such enhancement of transfer tools should avoid fragmentation of the banking union through over-reliance on the national instruments, tools, and sources of funding. This is why EDIS at European level is, in our view, so important. As you all know, we are discussing EDIS in different fora. At first stage, based on the hybrid model of EDIS, allowing for a smooth transition towards a fully fledged EDIS may help us getting away from the current political deadlock. This includes mandatory lending, another point mentioned by Christus. My sixth and last point refers to state aid. We need to revise the 13th Commission communication to reduce the incentives that may increase the likelihood of circumventing the resolution framework. The existing inconsistency in burden sharing is not justifiable. However, I do not share Christopher's general criticism to the existing access criteria to the SRF, which reach the adequate balance between access to external funding and burden sharing for shareholders and creditors. I would not consider justifiable to introduce differentiation between banks for access to the SRF. To conclude, I want to once again thank Christos for this interesting presentation. I'm sure many of these topics will be discussed at length over the coming months, and the SRB looks forward to actively engaging in such discussions. Thank you very much.
Thank you, Jan. That was a very thoughtful response to Christos' proposals. I now open the Q&A session, and I've already received quite a big number of questions. So sorry if we don't have time to consider all of them. And I don't want to repeat those questions that basically have already mentioned by Jan, essentially in some form or another. But here's one interesting comment that I received from Ignacio Tirado, who's also, maybe looking, Christos, at the theme, not just from a European, but also more from a global perspective and from a UniCredit informed perspective. And his point is that, if a harmonization of liquidation proceedings is to be achieved, then he argues that some sort of leveling up of the waterfall hierarchy of claims would be inevitable. And would you agree with that? And if so, how would you undertake such a task? Because claim hierarchy in insolvency reflects, at least in part, a society's value. And so it seems politically difficult to achieve uniformity in that context. So the question is basically, is there a common ground which might be agreeable to all? Whether you see any potential for making this actually a practical reality. So maybe that's something you can comment on, Christos, and maybe you also want to pick up some, but please not all of the points that Jan raised in his comment. Thank you.
Let me respond very briefly to both to Ignacio Tirado and to the comments. First of all, I was very happy to hear Jan Reinder's response, because essentially we see eye to eye. There is no fundamental difference despite appearances. Why? What I simply say is that the liquidation rules should be grafted into the BRRD. I also mentioned in my presentation, in the written version, I did not mention, it was the last slide that I did not show, that preferably it should be a single European authority, namely the SRB, which should trigger the procedure and choose the tools. If so, the real problem, which is mistrust between the member states. Some member states believe that liquidation, especially liquidation involving external funding, will be a recipe for disaster because governments will circumvent the restrictions of the regime in order to utilize public funds to support failed institutions. If, however, the support would come from EDIS, or even if it would come from national deposit guarantees funds, but under the tutelage, under the decision-making responsibility of the SRB, this would be a non-issue. Then again, in procedural terms, what's wrong with grafting the common liquidation rules in the BRRD so that following the failing or likely to fail decision, it should be decided what the proper path of resolving the crisis should be. I don't see any problem with Jan Ryder's point about special rules for large banks, because this can happen. Exactly as in the SSM, we have differentiation, but still a single system for the withdrawal of license. Here too, we could have a single system with proportionality and gradation. If it were not national governments that choose, but some European authority under common criteria, what is the problem with that? Why shouldn't it be unified? Now, a point about the hierarchy, which also was indirectly raised in the written questions about the relationship between least cost resolution with P&As and the no creditor worse off. Definitely, in order for the system, any system, even the separate system to work, you need to rethink, and on this we agree with Jan Reinder, we need to rethink the role of the DGS and the super priority of the DGS when it is subrogated to depositors' claims. This definitely needs special technical thinking. Do we need a more general harmonization of the ranking of creditors, and how would we achieve it? Well, it has been done before. We have the Winding Up Directive, which partially harmonizes the ladder both for liquidation and for restructuring. And to my mind, it is not really the case that nations, the member states, are really hyped up because in the mind of the voter, in the mind of the citizen, the hierarchy of creditors is such an important issue. This argument that deeply ingrained national ideals go into the insolvency process, well, I don't buy this argument. I think that we could move gradually, carefully, without exaggeration, and by recognizing national differences towards a more coherent set of priorities. And remember, the BRRD already does that. There is a clear tendency to align the order of priorities in insolvency with the order of priorities in resolution through the norms both in the BRRD and in the SRMR, in the Single Resolution Mechanism regulation. So we should gradually go towards a unified ladder of creditors hierarchy for banks across Europe, since we have decided that banks should be managed centrally by the two single mechanisms.
Thank you. Just a quick follow-up from the audience. Marieke van Hoeken has asked a question which is quite related on how the no creditor worse off thing would operate under your proposal, right? So what would be the correct counterfactual? Because at the moment we're comparing a resolution with sort of ordinary liquidation, and so how would you make that operational in your model?
Is this addressed to me or to Jan Reinder? I believe that it should be harmonized by the EBA. The EBA should be able to issue an RTS setting out exact methodologies. You cannot have separate, this is a critical question. You cannot have national choices when European money is expended. You need to have a uniform solution. This is why I claim that this should be done by the SRB, but even if it is not done by the SRB, it should be done under very clear criteria on the basis of a single methodology, and of course the single methodology should be for the EBA to define. On top of that, I firmly believe that you should not go for minimalism. Think about it this way. The minimalists who say only the strictest possible criteria think about protecting the banking sector's funds because the banking sector finances the DGS. But isn't it to the interest of all banks to have orderly liquidation and depositor confidence and investor confidence in the banking market? Doesn't the overall effect of liquidation affect every single bank in the country? Isn't it preferable to be a bit generous with the DGS participation in order to have truly orderly proceedings? Again, the FDIS, I mean the American system, provides very good grounds, but I have to say to you, you know something about Denmark, you have worked there, that the Danish system is very rational. And I would go a little bit further than that, but this is up for discussion.
Right. Just one final quick point which came up in the chat, and it's an interesting thought. I mean, at the moment, one part of the problem seems to be, at least that's also what you say, Christos, that the public interest is somehow hijacked by national governments in interpreting it. And if we now move in your proposal to a European system, basically it would also mean a European public interest test. And wouldn't we just shift the whole level, the problem to the European level. So wouldn't, the European Union, for example, use its public interest test, probably also for European reasons, which might then equally strongly affect world stability rather than European stability? So in other words, would we just shift the same problem to the European level?
Let me be absolutely clear here. I have heard many people saying that we have a conflict between, for instance, Italian law and European law. That's not true, because this is not one public interest test. There are two public interest tests. The one asks, should this bank be placed in resolution on grounds of systemic stability, the criteria in the BRRD. The other test says, should Veneto suffer concentrated local losses? This is not an issue covered by the BRRD. It's a different concept of public interest. Public interest is not only the 5 criteria in the BRRD, the criteria in the SRMR. No, public interest is a much broader set of considerations that may justify state aid. The reason for which this is not problematical, if you have separate proceedings, if you don't have a unified system as I propose, if you have the current system, the way for which this is not problematical is that the bank has already been extirpated. There are no real competition reasons because the bank has been put out of its misery. The shareholders have been extirpated. The junior bondholders have been extirpated. And then the Italian state wants to preserve stability in the local economy. Why not? What is the problem with that? State aid is not a general economic governance mechanism. It is a competition preserving mechanism. What is the specific benefit to the acquirer? Nothing. It has paid value for money. What is the specific benefit to the debt bank? Nothing. It has died. So why should we use state aid considerations across the board when they do not apply? And why should we use a public interest test which simply distinguishes between liquidation and resolution about procedural streams as a factor when you actually apply liquidation tools? I don't see the point.
Good. Okay, thanks. That's at least a clear statement. I'm sorry that I have to close this very interesting discussion. There were many other questions in the chat. I'm sorry that we don't have time to go through all of them. May I suggest that you either use email or other means of communicating directly with the speaker afterwards. But thank you so much, Christos and Jan, for a very, very interesting opening session. It's been very, very interesting to listen to you. Thank you. That brings us to the next topic. Part 2 is devoted to the impact of Brexit on resolution. And our speaker in this session is Matthias Lehmann, a professor of comparative law at the University of Vienna, and he will speak about the post-Brexit world and the importance of international standard setting. The respondent will be Sami Harras, head of strategy, international relations and communications at the SRB. Matthias, do get started. Thank you.
Thank you very much. For this kind introduction. Well, post-Brexit, totally different topic seemingly, but we are still in the world of resolution. I'm going to address this in 4 points. We are first looking at the situation basically before the end of the transition period on the 1st of January this year. Then we look at the sea change caused by Brexit and the end of the transition period. I will give you an overview over possible forms of collaboration before making a practical proposal how we could take the relationship with the UK forward. So starting point was, of course, that the UK was a EU member state, and is in this capacity, it was bound by EU regulations. It also very much transposed EU directives. I think the UK was one of the most faithful member states in the Union, and against the odds, it also transposed the latest revision of the BRRD, the BRRD2, that came into force only on the 28th of December, so merely 3 days before the end of the transition period. And the UK nevertheless transposed this change in the Banking Act in the version of 2020. before Brexit, the UK also had to follow the decisions of EU authorities, including decisions by the SRB that were then rubber-stamped by the Commission, and it was bound by interpretations of the CGEU. Now, there were some difficulties which shall not be denied. There was this famous case, Goldman Sachs International versus Novo Banco, in which certain debt that was owed by Novo Banco was transferred to was owed by Banco Espírito Santo was transferred to Novo Banco, and some debts were excluded, especially those of Goldman Sachs. And at the beginning, it seemed like they were not excluded, but then the Portuguese Resolution Authority made a clarification in a December decision saying, well, they are excluded. And the question was, what is the effect of this clarification in the UK? And Justice Hamblin, in a decision by the High Court, denied any effect of the later clarification. He gave effect to the transfer of August, but not to the clarification in December, by arguing, well, we just have to recognize the August decision, and later clarifications by foreign regulators don't count. That was eventually, unfortunately, corrected by the UK Supreme Court in a very important judgment, but you see that there can be misunderstandings in relation to the UK. And it was helpful, I think, that in the background, the CGEU was looming. That would have probably adopted the same interpretation as the UK Supreme Court did. So now, of course, the UK is no longer a member state, and this means that basically EU texts are no longer applicable and decisions are no longer binding, and especially also interpretations of the CGEU are not binding either. This is mitigated to some extent by a British Act, the European Withdrawal Act 2018, which basically transfers, copy and pastes all of the EU-derived legislation. It saves the EU-derived domestic legislation, so everything that is transposed from directives, and it copies and pastes all the EU regulations and other directly applicable texts into UK law. And especially it also says that all of the old interpretations by the CGEU that have been rendered before the end of the transition period will be retained. However, with the UK now being outside of the Union, the decisions of EU authorities are no longer binding, and interpretations of the Court of Justice are not binding either. The European Union Withdrawal Act just foresees that courts or tribunals may have regard, mind the word regard, to anything done on or after exit day by the European Court, as they call it. But this is purely optional. And especially even this optional regard leaves open the possibility that the legislator specifically diverges from EU law. This is a possibility, of course, for the UK. For instance, we could think, or we could imagine that the UK might deviate from the Emerald standard of the EU. It could, for instance, limit the Emerald standard to just GSIPs, which would be totally in line with the recommendations by the FSB and also with what is done in the US. So the UK is always looking now to the US more than the European Union. So they could imitate that, and to be more competitive, they could argue. But let's not forget that also the EU might deviate from the current standard and may have a legitimate interest in doing so by, for instance, reforming and strengthening MREL in a, what I provisionally call a BRRD3. So what are the chances that this divergence happens? Well, from the UK side, we already have a number of indications that divergence is in the cards. And that is not only by Brexiteers like Owen Paterson or Ian Duncan Smith, but also Philip Hammond, which is not really a standard type Brexiteer, indicated the possibility that the UK will have to change its model, its economic model after Brexit, just to compensate for the effects of Brexit, which he sees as negative. So the EU and the UK could be seen as being involved in a strategic game, and game theory provides some models for analyzing this type of situation. One model that game theory has developed for this type of situation is a so-called coordination game. So we could see the UK and the EU being involved in a game where they search for coordinating their legislation. And you can see here, this is a typical representation of a coordination game. I've just made up some numbers, but the point is that you see if the EU on the left side would choose EU law and the UK would do the same, that would be one type of ideal situation for both of them, a dominant situation, an equilibrium, Nash equilibrium, better than any other situation. It would also be okay if both parties would agree on using the UK standard. That's still better than having no common standard. In this situation where the EU law is chosen, of course, the EU is a little bit in a better position because they don't have to change their law. If the UK law is chosen, then the UK is in a little bit better position, as indicated by the numbers 3 and 2 or 2 and 3. But if, for instance, the EU chooses UK law on the left side and the UK chooses EU law, right, both would be worse off because that would be a change for both of them without getting harmonization. If the EU would stick to EU law and the UK would stick to UK law, that would not involve any costs of transition, but still they would not have a coordinated regime. So in this coordination game, everybody strives at least towards a common denominator. However, I don't think that we are in this type of situation because the laws of the UK and the EU are already coordinated. So they are starting from a common basis. And the question is then rather that of a somewhat boring, because standard, but still very, very common prisoner's dilemma, in which both parties have an incentive to deviate. So here, the EU and the UK could stay aligned. We would be in the upper left quadrant, and they would be both at a position of 2. But if the EU stayed aligned to EU law and the UK would deviate, which is on the upper right quadrant, then the EU would suffer because it would have a very competitive financial market outside of its borders, which has access to its market, because we are still in a situation where they grant, or where the EU would supposedly grant equivalence to the UK, and the UK would benefit enormously. At the same time, we could also envisage that the EU deviates from the common situation and the UK stays at where it is. So that would be the dominant strategy for the EU, to improve its laws and to hope that the UK would still provide financial services and also grant access to EU financial institutions. What I'm somehow supposing here is that both parties grant each other market access, which is not the situation currently, but which we'll probably see in the near future. When the deviation is so big, of course, that equivalence cannot be granted, then both would be suffering, I guess. So we have this prisoner's dilemma, and we have incentives on both sides to deviate. And the question is, how can we overcome this? Because this situation is suboptimal from a general point of view. It would be better if both stayed aligned. So collaboration can overcome prisoners' dilemmas. And there are different forms of collaborations that we could imagine. There is a multilateral collaboration in one of the many fora that we have for this, through different instruments like treaties, standards, model laws, and so on. And the advantage of these multilateral forms of collaboration is, of course, we have a high number of participants and therefore a more or less global level playing field. And also, these international institutions provide a very neutral ground for negotiation, which is not fraught with any disputes that the UK and the EU might have bilaterally. On the other hand, the divergence in this broad spectrum of countries is really high, and that results in outcomes in legal texts that are often very abstract and don't go into any detail. And for two economies like that of the UK and the EU, I guess that a text like the key attributes by the FSB is just too general to be of any practical use. So I don't think that these international fora really provide the place where we can solve the problems with two neighbors that are so closely intertwined as the UK and the EU. Now, we also have a lower level of collaboration between regulators, which the SRB, of course, will like a lot and which it's used to, and which comes in different fora like regulatory dialogue, but also the common resolution colleges, for instance, that exist. And also there we have a number of instruments, for instance, the Memorandum of Understanding, which is currently much talked about between the UK and the EU. Now, the advantage of this, of course, is that these types of instruments are, and the participants are highly professional, of course, on both sides, very specialized authorities. The texts are very granular and detailed. They also provide a lot of flexibility. And, well, I wouldn't say that they're completely useless because they're non-binding. On the contrary, Chris Brummer and others have argued that regulators have an incentive to respect, for instance, memoranda of understanding, even though they are not legally binding, because they want to maintain their reputation in the relation with the other regulator. On the other hand, at the end, the buck stops at the law. So these texts are not legally binding. They're declarations of intent, and they can be revoked most at any time, basically, and they're subject to important limitations. That is the case, for instance, if we look at the cooperation agreement that the Bank of England and the SRB have concluded last year. No, already 2 years ago now, in 2021. And that provides for consultation, cooperation, and exchange of information, probably highly valued at the SRB. And I'm sure that there is a very good personal relationship with the Bank of England. I trust that to be the case. However, when it comes down to a situation of a major breakdown of a bank in the UK or in the European Union, right? I doubt very much that we can rely on this cooperation agreement. Right? When the push comes to shove, it's always, the national interest always comes first. The asset grabbing and so on is a phenomenon that cannot be denied, and a memorandum of understanding will not help. Especially the text is also very clear that this is only a statement of intent, not binding, and does not create any legally binding obligations. So I don't think that the situation where really much is at stake, we can rely on this. There are more formal types of cooperation, like a treaty, for instance, the Trade and Cooperation Agreement that we have between the EU and the UK, which also has a dispute resolution mechanism integrated in it, but it doesn't address resolution. And we can have formal agreements even between supervisors, binding agreements, not mere memoranda of understanding. There are examples of this, like the multi-jurisdictional disclosure system between the United States and Canada. Here we have legal binding obligations, and since this is only bilateral, it's also very specific and granular. The only downside I see is, well, you also have to accept and to swallow the bitter pill that sometimes you have to respect resolution measures of the other side, which you don't like. But I think that is a consequence of reciprocity, right? You cannot have your cake and eat it, as the Brexiters have suggested. If you want the UK to recognize and enforce European resolution measures, then you must do the same for the UK within certain limits. Now, to my practical proposal. So I think that the markets of the EU and the UK are too much intertwined to just leave it to regulatory forms of non-binding cooperation. There are many linkages on the systemic level, on the institutional level, on the product level that suggest we need something more, a closer regime that is also legally binding. The Trade and Cooperation Agreement that has been closed on Christmas Day of 2020 does not address a restructuring resolution, and I don't think that the Memorandum of Understanding that the EU is about to close with the UK, probably in March, will address this in any meaningful way either, except maybe for information exchange. And the standard third country regime that we have in the BRRD is certainly not sufficient for some country that is so important for the European financial industry like the UK. So what can we do? Well, the BRRD provides us with some tools that we could use. We could have a Commission and the UK, right? We could also have a binding agreement between member states and the UK, only in case that the Commission has not concluded such an agreement. Or we could have a non-binding framework agreement between the EBA and the UK. Of course, my preference would be something binding, so option 1 or 2. Now, in parentheses, there is a way around, yeah? Sorry, I need to come to an end. So just to make clear that, and maybe we'll discuss that also with Sami in the next minutes, contractual recognition, in my view, is not the solution for different reasons. You can include, of course, in MREL instruments, you can include an obligation to respect resolution measures by the other side, but it does not work for old instruments. It's costly to renegotiate legacy instruments, and especially it doesn't apply for anything that's not bail-in, like asset separation or transfer to a bridge institution and so on. So I'm cutting this short a little bit and make my proposal. I would think that the Commission should enter into a bilateral agreement with the UK that should be binding, and we need a dispute resolution mechanism, and it should address all the points that are foreseen in the BRRD and even more. And it should also, I would say, not only apply for banks that have branches or other establishments in the EU, but also for those that don't and that will be allowed to provide services, financial services in the EU. The question is, why should the UK accept? Well, the SRB in the EBA constantly advise against the use of English law because of the uncertainty due to Brexit. I think that could be removed should the UK sign such a binding agreement, and they would have reciprocity. I would also argue that we should include in the assessment of equivalence the question whether the UK recognizes SRB resolution actions or not. And with that, I'll leave it there. Thank you very much.
Thank you, Matthias. Terrific. We have a great proposal on the table. I hope that everybody in the UK and in the European Commission is listening. But now for the discussant, Sami Harras from the SRB. Thank you.
Thanks a lot, and delighted to be speaking here, and also delighted about the audience that's joining us even from as far afield as Asia at this, what for them is a late hour. I think Matthias has laid out very pertinent questions and potential answers in his impressive presentation, and I do hope, Georg, that the Brits are watching this. I was particularly intrigued by the element of game theory analysis he presented and how he showed the prisoner's dilemma we are in, although some might say it's not a prison at all, but a nice palace, and we quite like being in it. So sorry you left the palace, but let's try and make the best of it. Brexit, as Matthias has said, presents a sea change for Europe, and it will be a long time before we've discovered all the areas it affects and how it will affect them. An MOU, as you have rightly said, will not be a magic solution. I mean, we see the dialogues and fora we have with the USA, with Japan, with China, with other jurisdictions which are based on a similar framework. And these are really highly general fora where people have the possibility to exchange, to also solve some problems, but they're not a replacement for being in the single market or in a similar jurisdiction. But allow me to take a step back and look at the bigger picture. The 2008-2009 financial crisis presented, in my view, a triple problem. We had limited or no regulation for the cross-border failure of banks. We had limited or no authorities that could deal properly with the failure of such banks. And we had no cooperation. And for that, we just have to look at Lehman Brothers. And the funny thing when I go to international fora is how different the narrative on Lehman Brothers is for me as a German versus our American friends. So in America, the bondholders basically lost everything. And the German bondholders were made whole as the outcome. Now, this is of course different. It's an insolvency proceeding. You know, many differences. However, it just goes to show that you come to an unfair solution if you just let the chance of where a bank fails and where the assets are at that particular point in time decide what the outcome is, and a more just solution can be achieved, and you can even achieve more by avoiding it to go down the route of insolvency in the first place. Now, this has changed with the FSB and the G20 framework, the key attributes, the quasi-permanent bodies in the FSB, the Cross-Border Crisis Management Group, of which Andrew Gracie, who will be speaking in the next panel, used to be the chair, where the UK is a key authority around the table, and there's no two way about it. It's almost like the UN Security Council. The US and the UK are two key authorities around that table. The EU is another key authority around that table. So the most important jurisdictions have since then established dedicated authorities which are continuously in touch with each other at every level of seniority and at every level of the issues. Information between the authorities is shared, and that is the benefit of the agreements we have between the authorities, in a targeted and standardized way. So we are all communicating with each other, and we can do so with real life data about real life cases and real life problems. The people in the organizations know and trust each other. And all this is new. This was not the case in the same way in the 2008-2009 scenario. On top of this, we have actually introduced dedicated capital and other requirements, and we benefit from these greatly today. It's hard to imagine the state of panic we would be in today if we had not taken these measures after the last crisis. So they're benefiting us even in an event where it is not a bank-led crisis scenario. However, as Matthias has pointed out in the example of the UK, there are limited formal powers. The unique situation in the EU is that we are the only place in the world where there's a cross-individual member state jurisdiction that allows us to apply law across borders. This is not the case beyond the EU. This will not pose a problem as long as the sun is shining, but it may lead us to difficulty when there is potential pain involved. I think Banco Popular has shown beautiful that without formal powers, authorities are collaborating when the case is simple and relatively speaking small. But what will happen if there is a GSIB failure? Will we go back to the Lehman Brothers world? So back to the question of international standard setting. Brexit, but also unilateralism more generally, because it's not just Brexit is just a symptom in a way of a general unilateralist movement that we've observed over the last years in many fields, and not driven by the financial authorities at all, but coming from completely different political considerations. We risk moving from a win-win to a zero-sum, which is really lose-lose, as it will include ring fencing, it will raise the costs, and will hinder market efficiency. The UK was always between two worlds. The question is whether going forward it will align itself more closely, even more closely with the US, and what will that mean for international standard setting? Who can be the driver of international progress? Will we see a world where bank lobbying to reverse reforms will continue unhindered? Will we continue to suffer from the prevention paradox? Taxpayers not realizing that they've been saved, and media focusing on those who have lost without explaining the alternative properly. The risk of a continued slowdown in international regulatory standard setting below even the lowest common denominator. But there is also an optimistic scenario. There's a scenario where the UK behaves more like other medium-sized jurisdictions, where the UK realizes how vulnerable it is and how terrible a disorderly bank failure would be, and to actually become a champion of regulation. And I think we can observe this to some extent in other medium-sized jurisdictions like Switzerland. And there's some hints that the UK might actually be going down that route and become what we call in German der Musterschüler, on the regulatory side, a model pupil. I think the framework we have put in place has a chance to prove it's working. The benefits of cooperation are evident. A backlash against unilateralism is possible. And with the UK now no longer at the internal table, Europe may find its own stronger voice at the international table. I know it sounds counterintuitive, but think about it. Brexit has shown into relief that we are at another fork on the road. Do we want to return to the lose-lose zero-sum world of before, or do we want to move forward? I am by nature optimist, and while I deeply regret Brexit, and it affects my family as well, I believe that we have a chance to continue the road that we have started, that the mutual interest will in the end trump, forgive my word, individual interest, and that we will be able to continue to develop and improve our international framework in a way that improves financial stability and continues to shift the burden to those who should and can carry it. But I'm really curious and looking forward to what the audience has to say about this. Thank you.
Thank you, Sammy. That was very thoughtful, and I'm sure we have a lot to discuss in that context. Let me just pick up your comments with something that came up in the chat and that I would like to put to Matthias, a bit of a more pessimistic view, if I may say. So, contrasting nicely Sammy's rather optimistic perspective. So there is the case to be made that even if we had a formal agreement of cooperation, right, even, if you tick all the boxes with a legally binding thing between the SRB and the Bank of England, let's say, right? Let's imagine, switch back 12 years to the major banking crisis. We have another big global bank that is in failing. Would then, really, when push comes to shove, either side on the channel really, not be tempted to renege on those promises? That if there's really such a major banking failure and the entire economy is about to explode, and wouldn't there be this sort of race that we saw basically in rescuing Lehman, for example, where there was a lot of activity going on in twisting that sort of resolution operation to your own favor? So that's a question that comes up, and I think that is a nicely additional point to the set of options that was given by Sami. But maybe, Matthias, you would like to comment on all of those points together.
Yes, first of all, I want to thank Sami for his really thoughtful comment, and I agree with almost everything he said. I really liked his outlook, and I'm very hopeful as well that the UK will behave. My worry is just being a lawyer. What happens in case they don't? And I agree also with the attendant who asked this question: what happens if we have another Lehman crisis? Unfortunately, I have the same family name, although I stress always that I am written with double N. So if we had a Lehman repeat, what would happen? There is no foolproof solution for that, of course, and even a legally binding agreement cannot make sure that UK authorities and courts would respect this agreement in such a case of where it is in the overwhelming national interest to just preserve assets that are situated in the UK. You remember what happened to the Icelandic bank whose assets were frozen in the UK using legislation for terrorist acts, right? So there can be creative interpretation, even of legally binding instruments, of course. But what I think is there is a difference between having a legally binding instrument or not. A legally binding instrument creates an additional hurdle. We have seen that the UK government has struggled very much to pass legislation in the House of Parliament, allowing them to deviate from the agreement that they had concluded with the EU 1 year earlier. And it was criticized not so much for the fact that it was against the EU or something. Even Brexiteers were against this, arguing it sets a very low example if you deviate from binding agreements. It violates the rule of law. And I think the rule of law is something that is very dear to the British. And we can trust that normally, let's say we can trust that the UK courts will do their utmost to respect the rule of law and uphold it. I'm not so sure when it comes to the UK government, to be perfectly honest. The government, follows political preferences and can be composed differently next year. We don't know. We cannot look forward, or we don't have a crystal ball to see who's going to be in charge. So that's why I would like to add an additional safety belt with a legally binding agreement, although I know it's not 100% proof. You have to unmute, Georg. Sorry.
Sorry, the classical problem. Somebody gave me a T-shirt once which says "You are still muted." That's the thing to wear in these events. Yes, Matthias. One other question that came up here is: could you comment on the requirements to prescribe an intermediate holding company? I mean, there are some supporters of the idea that any foreign bank, and that is sort of an EU push to have any foreign bank and that is present in the EU needs to have this intermediate holding company requirement for alleged facilitating resolution, which would be seen by some as also a response to the separation from the UK.
Well, the intermediate holding company, I think, when it was introduced into EU law, it was basically a reaction to similar developments in the US law. And I am not entirely sure, maybe Sami can comment on that, whether this is really needed from a resolution point of view, or whether this is just a pity reaction to what happened on the other side of the Atlantic. You do that, and we do that, tit for tat. I'm generally not in favor of imposing unilaterally additional obligations to banks that want to do a cross-border business, especially when it comes to structural measures. I just think that leads to more deglobalization, territorialization, fragmentation of finance. So I'm generally not in favor, but maybe Sami can say whether this is preferable from a resolution point of view.
Yeah, I mean, I don't think it was necessarily a reaction to the US situation per se. It was more a reaction to bank behavior. So banks deliberately moving themselves within the EU to a jurisdiction where they're suddenly no longer the biggest or second biggest bank in that country, by going to another jurisdiction to avoid being supervised by the SSM. So I think this is more a protective move by the regulators to react to naughty behavior by banks. And it turned out to not be such a big issue in the end. I mean, I remember banks were quite upset about it initially, but the discussion has really quietened down a lot.
There's one further question, Sami, which you might be best posed to answer if you have any views on this. A question asked by Stefano Rosetto, who asked, will the SRB formally confirm the ML disqualification of certain English law bonds post-Brexit agreement?
But I think all the banks have been told very clearly that they are expected to phase out their legacy bonds, and they are, as far as I know, they are doing it. So I think this will become, over a very short time space, maybe 2-3 years, I think this will become a purely legacy question. I think there's no need to panic over it or to make a big deal out of it. That's just a transition as far as I'm aware, and I'm not 100% aware because that's not, I don't have the latest overview. But as far as I know, banks are actively replacing their legacy instruments issued under English law with instruments that we have a good confidence in. Maybe if I can quickly tap into something Matthias said about the, I agree with him. I have complete confidence in the UK legal system. It is not without reason that it's a world famous legal system with very reliable court judgments. But of course, in the heat of a resolution weekend, it doesn't help us to be right afterwards. It's like the famous gravestone inscription, but he had priority. So you need to not just be in the right, you need to also get the right when it's your turn, and there the risk is indeed much bigger. It's a political risk.
Mm-hmm. May I also ask a question to Sami, if I may? You mentioned so the phasing out of bonds under English law, or the recommendation to replace them. Is that a general aversion to English law governed bonds, or do you accept English law governed bonds when they have this contractual resolution clause in it, where you oblige yourself to respect any resolution measure by the SRB or a national authority?
I think I know the answer to that, but I'm not sure enough to answer in this forum. Okay. I'd have to come back to you.
Okay.
Great, thanks so much. This leaves a number of questions open, but this is the exciting topic of Brexit, which really is a sea change. And we've learned a lot from you, Matthias and Sami. Thank you so much for this very enriching discussion. Let me close this panel now and invite you all for a quick break. We are a little late with the schedule, so I take the liberty of shortening the break, and we come back in 5 minutes, please. So around 14:25 in Central European time. Thank you so much, and see you in a bit for the third panel. Thanks.
Thank you, Georg. Thank you, Sami.
Okay, shall we continue? Matthias, yes, you're there. Andrew, are you there as well?
Yes, Georg.
Okay, hi. Then let us move to the third session, and it's my pleasure to introduce Professor Matthias Hentjens, who's an EBI board member and a professor of law at University of Leiden in the Netherlands. He will speak about the home-host conflict in cross-border resolution between different member states, but maybe also beyond just the EU setting. And the discussant will be Andrew Gracie, who's now at Deloitte, formerly chaired the FSB working group on resolution and was with the Bank of England. Matthias, the floor is yours.
Thank you very much, Georg, for this kind introduction. Many thanks also to the Single Resolution Board for hosting this this great conference. I feel truly honored to be speaking to this on this occasion, and humbled also a bit because, well, the topic I'm about to speak on, a lot of it has already been said on this topic in the previous presentation. So I will try to make that into a coherent whole in my presentation. And the topic is also close to my heart. I remember very much when I was a young lawyer, having been working for a year on the takeover of a major Dutch bank, and then after a year of very hard work, I allowed myself a couple of days holiday in Sicily in October. It was October 2008, and by now the audience will guess where I'm driving at. A couple of days holiday in Sicily, the only place in Europe where we thought it would be quite nice and warm. So I remember being at the beach in the rain, getting calls from my colleagues at the firm saying that ABN AMRO was nationalized. So that has been a national trauma for the Netherlands and for Belgium, and also a bit for Luxembourg, and also for many of us involved. So can you please, if we move on to the next slide, here you see a picture of, well, exactly that moment where the Dutch Prime Minister, the Dutch Minister of Finance, and the President of Dutch Central Bank announced nationalization. So what we had here was, jurisdictions who had been very, very closely intertwined, even more so than, well, what was the topic of last presentation, the UK and the EU, jurisdictions that were also for a long time even one country. But then when this bank failure happened, the interests were simply too large for, especially the political side, not to put national interest first. So that is, and the point was also made in the last presentation. So what we had here was, on the one hand, the political forces driving at less coordination. We saw jurisdictions that were very much close to each other, then becoming the bitterest of enemies in this large bank failure. So that's the political force. And on the other hand, the law can put a limit to that, and that can be a positive limit in the sense of imposing obligations to cooperate and to coordinate and to recognize resolution measures, and on the other hand, negative measures to limit the maybe political forces against cooperation and recognition. So that will be the topic of my presentation. I will zoom in on where we have come. Have we learned our lessons since 2008? This has also been addressed a couple of times now in the previous speakers. What have we learned, and to critically assess the state of the current state of play. What I will focus on is issues of recognition rather than cooperation, which may be in practice may be equally important. But that's the choice we made. So before we go on and look at the current framework, a couple of words on theoretical but important distinctions that need to be made. So if we please move to the following slide, because this is a very complex topic and a lot of various scenarios can be covered by it. First point is that when I talk about recognition, I mean recognition in a broader sense than the traditional private international law sense. I not only mean when I use recognition by courts, but also by authorities, resolution authorities recognizing or accepting resolution measures taken by foreign countries. I also use recognition in a broader sense, in the sense that I do not only use it as recognition in a strict sense, as accepting foreign resolution measures, but also actively taking supportive measures to support resolution measures taken in another jurisdiction. Now, what does the recognition concern? What can it cover? And there, I think it's important to be clear about that and make the distinction that it can cover a lot of different issues which sometimes fall together, sometimes they don't. So the first area where you think of when talking about home host balances is the group structure, where you have a group company parent in one jurisdiction, subsidiaries of the group in another jurisdiction, and then resolution measures being taken in one or the other jurisdiction. This is to be distinguished, I think, from the situation where you have creditors in another jurisdiction. You may well have the entire a bank in one jurisdiction and creditors in another jurisdiction. This also may raise home host balance issues. So I use home host here in a broader sense than the strict supervisory, technological or technical sense. And the same issue you have if you have assets in another jurisdiction, and that might also trigger home host balance concerns. A somewhat elusive matter is something that was addressed in the previous session, when you have the law of a third country applicable to, for instance, contracts, and this in certain private international law systems also creates jurisdiction, not in all, but in some. So there that also might trigger a home host in a broader sense concern. Now, where do we find the legal framework on various levels? First on the global level, and it has already been mentioned, the Financial Stability Board's key attributes are of paramount importance here. The FSB also issued specific principles on cross-border recognition, and the Basel Committee in an earlier stage also issued an important paper on the topic. Now, on the regional level, of course, there is much, and especially in Europe, and this is a point I will make or return to later on. In Europe, we have a very elaborate system of home host balance and recognition. On the national level, somewhat less so, but we'll get to that. Yes, next slide, please. And now, where does that leave us, or what is the current state of play in the EU, and how far or how not far did we come when considering the situation in October 2008, when this trauma happened with the Fortis ABN AMRO nationalizations? Well, first, again, distinctions need to be made. I made three main distinctions. The first one, within the banking union, where the highest level of supranational harmonization has taken place. There is a supranational resolution authority, the SRB, of course. We even have unified regulation through the SRMR, and also through the credit institutions winding up directive, we have a high level of recognition also in a more technical private international law sense. But, and this has also been raised in the first session, whilst we have a harmonized substantive law system through the BRRD and even the SRMR, the no creditor worse off principle is a central element in those instruments. Exactly this principle results in different applications of the BRRD in various member states because they have their own systems of national insolvency laws. And this may be an impediment to also to recognition and even cooperation, because if under this principle and because of the counterfactual, as Christos Hadji-Emmanuel defined it, if you have divergent application, divergent treatment of creditors in one jurisdiction compared to the other, that may be an impediment to cooperation and recognition. This will be a point that I will be returning to. But again, this is less of an issue within the European Banking Union, where the SRB is the resolution authority. It will be more of a problem in situations where you have EU, broadly speaking, a banking union. There is indeed harmonized regulation through the BRRD with its safeguards, explicit safeguards for creditors. You also have the Credit Institution Winding Up Directive and very specific, and this is unique, specific provisions on cross-border resolution. But again, there is the no creditor worse off principle, which may result in divergent application of the BRRD. And of course, there is no supranational authority, resolution authority, that is. What's more, there are even explicit grounds for departure from group resolution and specific ground for not participating or not joining the group resolution decision is financial stability consideration, and I will return to that later. Now, on the global level, so both inbound and outbound resolution, if you like, concerning the banking union and the EU vis-a-vis third countries, the US, China, and now also the UK. There is, of course, even less harmonization, even less unification. We do have the key attributes, and fortunately, many countries have implemented those, but we do not have the further reaching harmonization that we have on the European level. We have certain agreements, we have European resolution colleges, but again, there are explicit grounds for non-recognition, even on the European level, and less harmonization. So if we move on to the next slide, then it will become immediately apparent from my previous slides that there are still problems to solve. First, and this was again also addressed in the first session, there are still discrepancies and differences between national resolution laws, even within the EU, but certainly also on the global level. The obvious solution here would be harmonization, and this may be difficult, especially where it concerns creditor hierarchy, creditor priorities, but it has been shown that it can be done when we look, for instance, at Article 108 in the BRRD. There we see a very targeted type of harmonization of creditor priority. So this could be a way forward on this matter. Second issue, the absence of automatic recognition, especially on the global level. The solution here is memorandum of understanding, cooperation agreements, such as have been put in place between the Bank of England and the FDIC, between the Bank of England and the SRB. But as was stressed before, these are non-binding instruments. So it remains to be seen what that does in when push comes to shove in a real life case. The obvious solution here would be a binding convention, or another solution, as Matthias Lehman also advocated, but that will in the end depend on political will. And this political will may be informed by my third point, being that there will be exceptions for stability, financial stability reasons and fiscal impact, which are considerations that sovereigns are reluctant and unwilling to relinquish. A solution for this could be an obligation for a home member state to take into account host member state interests. I do not think it is realistic to assume that national member states or national jurisdictions will relinquish these grounds for not recognizing a resolution measures in another jurisdiction if they would be problematic from a financial stability or fiscal perspective. So the solution here could not be wholesale, but should be targeted. And I think an important topic here that would raise the chances of recognition and would raise the chances for a home state to take into account host state interests would be if the interests of creditors would be safeguarded by the home state. And this is the topic of the next slide. So I think the protection of creditors is an important topic, which may again raise the chances of recognition in the other jurisdiction. And this is confirmed by explicit provisions in EU legislation, Article 96, but also, for instance, in Article 5 of the Chinese enterprise bankruptcy law, which refers to the protection of creditors as a public policy ground not recognize foreign measures if they would be contrary to the interests of domestic creditors. So I think that the safeguarding of creditors, whether they be domestic or foreign, really is an important consideration to higher the chances, to raise the chances of recognition across borders. Now, in the Financial Stability Board's key attributes, a number of safeguards for creditors have already been included, and they have been transposed also in the European instruments. There is an explicit obligation not to discriminate against the creditors on the basis of nationality. I think that is a very basic but important provision. There is legal protection of creditors, whatever their nationality, by allowing them damages on certain grounds. For instance, if on the ground of no creditor worse off principle, again, we have it here, which also is another reason to wish to harmonize this area of national insolvency law. But there should be an adequate procedure for judicial review and again, an harmonization of creditor ranking. I think contractual recognition also helps in this respect. So the Article 66 contractual recognition, where it is contractually agreed that foreign resolution measures are recognized, at least between the parties. Another example of creditor protection across borders could be, or is, I think, the no cross-border cross-default rule in the BRD, which means that a default in one jurisdiction, in a home jurisdiction, does not lead to default in a contractual, from a contractual perspective, in the host jurisdictions, and the same applies to no ipso facto clauses. I think the no cherry picking clause is also a very important safeguard, which means that in a resolution measure, not one, if there is a netting agreement, a transfer tool cannot be used against one part of the netting, not one obligation, but it needs to be transferred as a whole. I will leave the reciprocity issue under Article 96 for now and move to my last slide. So where does this all leave us? Will there be no more trauma on a national level or on a personal level? I'm fairly optimistic where it regards the banking union. Maybe you could even say, as Dr. Koenig said in the beginning, there is the distinction home-host has lost relevance within the banking union, but I'm not so certain where it regards globally systemically important banks in a third country EU relationship. These banks still pose the biggest stability threats, but as we've seen in my earlier slide, global recognition here is least regulated. And here we return to the financial trilemma issue to which I hinted before, the exceptions for non-recognition being financial stability and fiscal implications. So this is our Rotterdam colleague Dirk Schoenmakers, a famous slide on the financial trilemma, where he shows that you can have only two sides of this triangle being honored or observed at this end, but not and never all three. So if you wish to have international banking and international financial stability, you cannot also have national financial policy. So if national sovereigns are unwilling to relinquish national financial policies, then one of the two, financial stability or international banking, has to give. So this will, I fear, remain to be an issue, especially on the global level. But there is some light at the horizon. In the end, I'm also an optimist, especially because I think that there is room for improvement. There can be made better foreseeable and more explicit regulation. Also on the global level, we've seen, well, I said before, the BRD has a very explicit provisions on international recognition. At the US level, there's far less, so there's certainly room for improvement, and in China even more. So no more trauma. It's a bit of a mixed picture, but I guess young lawyers will not have to fear, at least less, when it concerns intra-EU financial resolutions. Thank you very much.
Thank you, Matthias. That was an excellent start of this discussion. I have already a couple of questions in the chat. Can I just encourage everybody who's attending, please make use of the chat function to put your questions, and we will try to bring them in. But before that, let me give the word to Andrew Gracely from Deloitte.
Susan, if you could switch to the second slide, please. Thank you. Thank you very much. Sorry, let me start my video. Thanks very much for the invitation to speak today. Very interesting event. what I am going to do is build off Matthias's remarks, reflect on those, but with a British voice, I've probably got things to say about the preceding panel as well, which I found a very interesting characterization of UK attitudes to resolution and to MREL, given I was quite closely involved in the negotiation of BRD from a UK perspective, and I thought we had quite a large hand in driving it towards eliminating too big to fail rather than cutting corners. That said, in the cross-border context, there are clearly inherent legal and political challenges. I think they can or are being mitigated. And I think collectively, we need to have a glass half full view, because if we don't believe the glass is half full or can't be filled, we've got the wrong glass. You know, we should be moving to outlaw cross-border in some way. My slide is organized in 3 columns, as you can see. I've got 10 minutes, so it's roughly 3 minutes a column. Being sensitive to being a Brit post-Brexit, talking on the topic, I'll probably spend less time on the 3rd column. But let me start with the first one, which is the counsel for despair, as I've called it. The idea that achieving time-consistent arrangements around resolution for international banks is impossible, given how do you bind sovereign nations legally, and all sovereign nations in crisis are liable to respond to their own political interests. And that problem grows larger given the fragmentation in the international system. We have a lot of cross-border in the global financial system, in part because obviously we're intermediating real economy flows, but also regulation drives fragmentation. So if I'm an intermediary as a market participant, if I'm accessing clients, markets, financial market infrastructure, regulation very often obliges me to be localized. You have a Lehman's problem precisely because in servicing clients in the US, servicing clients in Europe, Lehman had to use different legal entities. So I think we need to recognize that. Second point is, this is all set up as if cross-border resolution is impossible. But we need to recognize that these potential coordination failures and frictions are not well addressed in existing international standards. We have a Basel Capital Accord for 40 years now, but it only applies on a consolidated basis. It doesn't say how much of the consolidated capital of international bank holds should be held in any particular jurisdiction or when it should move. And that's left to national laws and regulations. So when we're trying to solve for resolution, we actually need to solve for quite a lot of ex ante. And then the third counsel for despair is that resolution toolkits are only good for certain kinds of failure. Resolution provides mechanisms for capital reconstruction, continuation in critical functions by recapping them either through bail-in or by transferring them to someone else who can capitalize them. It doesn't deal with other causes of failure through contact, through financial crime, through cyber. And the financial stability externalities that will come from those sorts of shocks will be realized long before you need the capital generated through the resolution mechanism. So moving from there to the middle column, why then be hopeful? Firstly, everyone alights on Lehman, everyone alights on ABN, but historical experience is far from universally bleak. As Sami correctly pointed out, we went into the last financial crisis without resolution regimes adequate for large cross-border banks anywhere. More importantly, we didn't have any loss absorbency for resolution. So the only option to continue systemic functions were bailouts. But in doing those bailouts, where the risk to home financial stability was dominant, home country paid. And host countries supported that effort, most notably in US provision of dollar liquidity under swap lines between central banks. So US financial stability interest was protected because the UK authorities bailed out, and UK authorities did the ELA that enabled Barclays, etc., to carry on functioning. This goes to 2 points for me, I guess, which have largely been absent from the discussion to date, which I think are critical. One is the financial instability impacts of bank failure are often expressed both in home and host jurisdictions. And so interests can be aligned for that reason. And the second is business models. I mean, very often individual jurisdictions struggle to resile. If I look at a broker-dealer like Goldman Sachs, half of its balance sheet in London will be claims on the broker-dealer in the US, and vice versa. In other words, there's nowhere for the UK to go with the local broker-dealer of Goldman Sachs, which is going to get to a first best outcome. So there are grounds for cooperation. And that gets to the scope of interests. As Matthias outlined, it's possible to mitigate a number of legal issues. He quite rightly drew out the NCWO challenges of trying to apply resolution tools across multiple insolvency hierarchies. How do you solve for that in a practical way? Well, you solve for it through single point of entry, which is a dominant approach for most of the world's GSIBs, and implies applying bail-in one legal entity, in one jurisdiction, under one credit hierarchy. And the bondholders of the TLAC who bought the debt know that that's what the risk that they're going to be subject to. The second is recognition powers. And just to note, in sorrow more than anger, when the previous panel went to town on whether the UK would diverge and what it would do around recognition, not only did we advocate for the recognition power consistent with the key attributes to be in BRRD, but we've got one. You haven't got one in the US. And I'd be very interested to see Sami sit down and go through how well the US regime is reliable, given how important it is to significant European banks like Deutsche and BNP and so on. And the final one, we'll wait a long time before we get legal agreements that go much further than what we've got. Contracts are filling a large part of the whole. We talked about them in MREL and TLAC, and again, see no reason why a European bank should be able to issue under US law with a contractual clause and not be able to issue under English law with a contractual clause, especially since it's going to be cheaper for them to issue under English law than a lot of mainland European laws. I'd also point out, again on a Lehman's note, that a lot of the fallout from Lehman's related to disorderly closeout of OTC derivative contracts. Since 2015, there's been an ISDA protocol signed up to by all the GSIBs, which means that if the home country applies a stay to closeout and derivatives, it'll apply to their foreign law contracts as well. On mitigating political issues, the real issue here is that finance ministries didn't have an option in 2008. You address the political issue by giving the finance ministry a technical issue where their taxpayers don't pay. So let me lead that into the missing piece that I think has not been reflected adequately in this discussion, which is the paradigm of resolution is not only a toolkit, a legal toolkit to apply at the point of failure. It's a whole exercise of resolution planning to address the frictions, including cross-border, that will arise at failure, and to do that through crisis management groups. I prefer that rather than the parochial resolution colleges, if you're talking about third countries. The important issues there I pick out from the list are loss absorbency. It's important to solve not only for the quantum of loss absorbency in international firms, but also where it sits ex ante and how it's used in stress and in resolution. So that means a discussion around capital standards and also MREL and TLAC. And getting to a credible position on that will free up the question around liquidity backstops. Badgett says, lend to things that are solvent against adequate collateral in size. The whole point of MREL and TLAC is to unlock the potential coordination failure around central banks in multiple currencies being able to lend. A lot of examples were cited of failures since 2008. I would suggest that we need to avoid turning the clock down before the job is done on the resolution planning process and putting full stacks of MREL, etc. in place. I've successfully filibustered in a way that I won't talk about the third column, but bar this observation. A lot of the examples I've given to date relate to wholesale international banks. Retail banks are a different kettle of fish. They're politically more sensitive, and there's an identification with the safety net. I think from a banking union perspective, it's hard to see how you have a banking union if you're going to concede that certain banks, the messy middle that I've called them, aren't going to issue MREL. If their costs are going to go elsewhere, where are they going to go? And you're going to need to harmonize deposit insurance probably of some sort to provide for that. But let me note that very often the FDIC is presented as some nirvana in terms of its ability to apply its toolkit. I commend to you a speech by Marty Grunberg at the Brookings Institute a couple of years ago, where he pointed out quite correctly that above us, sure, the FDIC uses its toolkit for tiny banks, but for banks above a certain balance sheet size, IndyMac being a famous example, same size as Veneto, it was impossible for them to bear that through the diff. And in his view, something TLAC-like would be needed for DSIBs and regional banks in all cases. So I'll leave it there. Thank you.
Thank you, Andrew, for these very thoughtful comments, and also for making the connection between this panel and the last one. Indeed, there is some overlap. I'd like to push the discussion a little bit away from the B words, away from Brexit, by picking out one comment that came in from Laura Velasquez, who asked you, Matthias, whether you could comment and think a little bit about the political situation between a stronger and a less strong jurisdiction, right? So basically the question is whether there are any incentives for non-significant host jurisdictions to recognize foreign resolution measures. And she makes the point that there are usually that these less important host jurisdictions receive limited information on group resolution strategy, and it's therefore more likely that they may apply ring fencing activities. So I guess the question is going towards the power battle between stronger and weaker nations in cross-border resolution. Maybe that's something you could pick up.
Thanks for that. Very interesting issue. I think, well, this goes to the core issue, which Andrew addressed as well. But in the end, it's a matter of politics and how the law can shape it, and this can play out both ways, where it concerns weaker, stronger jurisdictions. You can also argue that there is an incentive for stronger host member states to not recognize foreign jurisdiction measures. I think we cannot fully take away this mechanism if we allow if jurisdictions wish to retain certain sovereignty as regards financial stability and fiscal implications. That's because of the financial trilemma that I referred to. But what we can do is put reassurances in place that assure that resolution measures taken by a home jurisdiction do not discriminate against domestic creditors, even if they are located in a weaker host jurisdiction. And those reassurances, they can be of various colors, such as the ones that I referred to earlier. And I think an important issue there is that the ranking of creditors is not significantly different in the home jurisdiction compared to the host jurisdiction, and this is again the NCWO issue and the great challenge of harmonization on that front. But there are other safeguards as well, which I've tried to list. So I hope this clarifies a bit.
Yes, thank you. Andrew, would you like to comment on this?
Yeah, so this is a classic problem. Small country got a financial stability exposure, not feeling it can address on the same level a large home. What I would say about that is that ultimately they have to choose, I guess, whether they want to put a fire gap between their own system and the parent, which would speak for pushing for separation of the local operation in capital terms, legal structure terms, operational terms from the rest of the group. But that carries cost in terms of the cost of intermediation within your system, and also the willingness of the home country commercially to commit capital to your jurisdiction. And then on the other hand, allowing the GSIB to operate locally in a more unfettered way. Paradoxically, we in the UK have found branch structures are excellent in those circumstances. We have branches of all the large international banks precisely because we know that the US couldn't cut off the London branch of JP Morgan, simply couldn't walk away. So I think from a resolution perspective, branches are a good idea. It creates other public policy challenges. I refer here to Estonia and Swedish banks, right, where domestic credit can get driven to a level that threatens financial stability because you don't have the controls that having a local incorporated entity to supervise provide you.
No, that's a great point. I mean, I think I agree with you. It's just this idea of branching sits somehow at odds with the international trend towards having more subsidiaries, right, and requiring intermediate holding companies and so forth. The branching thing seems to be rather unpopular.
So, well, it remains popular in the UK. I'm pleased to say.
Good for you.
And in Singapore and in Hong Kong. So, I think one's a tendency to look at IHC, look at IPU, and think branches are out of favour. But just on the note that I just said in terms of ring fencing, if you will, the operations of foreign banks in your jurisdiction, look at what's happened because the US imposed IHCs on foreign bank organizations. They have quartered in size since that was done. Now, these aren't the healthiest banks in the world that don't necessarily have the best business models in the world, but the result is inescapable. And again, I do wonder, I don't think the IPU for broker-dealer international bank type firms gets you much. The more restrictive in the operations under those IPU, the higher, the more you're going to be killing the golden goose in terms of what those firms might bring to European capital markets. And actually, I would say as a Brit, it's great for us, for UK Inc., because firms think, well, actually, I can make a much better use of my capital in the UK than I can tying it up in the European IPU.
All right, great. So thanks so much for this fascinating panel. Time is flying again, and we must draw this to a close. I particularly like the optimistic note of your second column, Andrew, and the point to say, and that's actually, quite straightforward to say, if we get the incentives right, then there will be more trust across borders, and hopefully that's the way forward to go, and also to reconcile this panel here with the previous one. But thanks so much for both of your contributions. It's been a very, very stimulating debate, and I hope we learn more about this in the future. Thank you. Let's move on and come to our fourth panel, which is going to be devoted to the topic of non-performing loans. And the work that underlies the presentation is the work of 4 scholars, all from Italy. Filippo Annunziata from University Bocconi in Milan, Antonella Schiarone Alibrandi from the Università Cattolica del Sacro Cuore, sorry for mispronouncing, then Ugo Malvagna, who is at the University of Trento, and Concetta Bresciamora from University of Roma 3. I understand only 2 of you present, I think, right? Ugo and
right.
I think. So I leave it to you how to allocate the presentation, and the discussant will be Boštjan Jašpek, Director of Resolution Planning and Decisions at the SRB. So Ugo, over to you.
Thank you, Georg. Thank you, and thank to the SRB and EBI for giving us the chance to participate in this convention. And as anticipated, Concetta and I are presenting also on behalf of the other authors a working paper where we focus on some of the various issues relating to the functionality of secondary market for NPLs, also in light of the strategy that was set out by the European Commission last December. More specifically, we are proceeding as follows. First, we will present the core elements of our analysis about the current situation and its expected developments in the light of the pandemic environment. Then we will briefly touch upon the dynamics that in the recent experience of secondary markets prompted somehow depression of NPLs market price. And then we will focus on the use of asset management companies and the so-called asset protection schemes as a jump starter of the market, that is, as a tool to provide transparency to the market. And finally, we will draw some considerations on the NPLs disposal ecosystem in the wake of the pandemic outbreak. Given this analysis, we will set out our proposals. There are threefold. First of all, we propose to pursue a level playing field through an EU level regulation with reference to loan participation funds that would help to mitigate some oligopoly issues that are present on the secondary market for NPLs. Then the second proposal is to embed NPL strategy in the management of the resilience and recovery facility in order to benefit non-performing debtors and indirectly benefiting creditors. And finally, we will discuss one really hot topic, that is the possible setup of an asset relief program carried out by a vehicle at the EU level, so an EU level AMC. So let's start. In general terms, we can say that NPLs involve the bank recovery and resolution framework in a twofold way, that is with reference to viable banks. NPLs and its characteristics in terms of size and vintage are one particularly relevant indicator of a bank's state of health that is basically kept under control, hopefully through ongoing supervision and this SRB. But on the other side, disposals of NPLs, perhaps in implementing a supervisory measure taken by the ECB, could themselves expose the credit institution to capital shortages. And when it comes to non-viable banks, high NPL stocks may somehow affect the conception and the implementation of the resolution strategy, thus directly impacting on the resolvability of the institution, both in the case of an open bank bail-in and in the case of rescuing bank and the sale of asset is part of the resolution strategy. And this is basically due to the uncertainty on the asset's value, that is the consequence of the inherent opaqueness of such assets, and the consequence also of the absence of a liquid market for them. So because of this, I think that we all have to agree about the fact that a developed and well-functioning secondary market for NPLs is also necessary from the perspective of resolution. And this is basically one firm point where there is a consensus, and also the recent action plan by the European Commission is in the same line. The problem is that even if since 2014, a secondary market for NPLs has developed in, at least in those countries that showed high stocks of NPLs, Italy in the first place of this ranking, this has not come without any costs or difficulties, because there are some factors that are affecting price formation mechanism in the secondary market for NPLs that depress the impaired assets market value way under their realistic value. And in our opinion, this is mainly due to three reasons. The first one is regulatory pressures towards disposals of NPLs and constraints in this respect that can, to make it short, can be traced back to the calendar provisioning rules. The second one is market failures, both in terms of asymmetric information and adverse selection that have led to high bid-ask spread, since the price offered by investors incorporates a risk premium and a liquidity premium. And also in the perspective of oligopoly, because the market for secondary market for NPLs is driven basically by hedge funds that are investing with quite a short time horizon, and of course they have a higher leverage than banks due to their structure that has an impact on the price. And finally, and this is something that we noted by observing the current experience of a big secondary market of NPLs as Italy is, but that is not commonly acknowledged by scholars and policymakers. There are some serious issues about the, let's say, the social sustainability of the business model that is widespread among purchasers and special servicers. And this is especially true with reference to SMEs and households, where the servicer's approach is basically oriented not to restructuring, but just to foreclose or repossess the main assets of the debtors, the immovable assets, of course. But in this case, all the collections and the performances of these vehicles will depend closely on the real estate market trends, which in turn will depend on macroeconomic performances. So if you have a recession going on, this is going to be problematic. And in fact, in these asset classes, recovery values have proven to be low because basically of an excessive offer of this immovable, that is the long-term effect of the 2000 crisis. But it's clear that beyond a certain threshold of offered immovables, this will affect the price formation mechanism. So we fear that on the medium term, such a situation would cause some kind of a doom blow between the debtor's social exclusion that won't be able to repay their debt, even as at the end of a foreclosure procedure, the asset depreciations and losses on the transfer banks. So all the above is problematic mainly for two reasons. On the one hand, per se, because it realizes a somehow unjustified transfer of resources from disposing banks to purchasers. And in the perspective of resolution, because losses arising from the disposal, from the underpricing of transferred asset as a consequence in the context of their disposal can be themselves the trigger, or at least can contribute to a financial institution distress. In the face of this, more than one country across Europe has experienced the use of public asset management companies and so-called asset protection schemes that worked as a tool to enhance the quality of the market and provide transparency and trust and incentivize participants to the market. Well, asset management companies, as everybody knows, they operate as a specialized investor and servicer, so they purchase NPLs, and so they work on the demand side. They are partly or wholly held or financed by national governments, whereas asset protection schemes that basically are state guarantees on the senior tranche of securitizations, they help because they create a sort of transparency effects because of the eligibility criteria that are provided for by the relevant regulation, which help to reduce the bid-ask spread. It's important to highlight that all the schemes that have been set up after the implementation of the single resolution mechanism are no aid, provided that asset management companies, they buy at market price, whereas asset protection schemes are subject to the market because only the senior tranche is guaranteed, whereas the equity tranche has to be placed on the market. And in any case, they charge a price for the guarantee that should be in line with the underlying value of the asset. So this is considered to be compliant with the private investor test. In order to be no aid, the purchase price should be the market price, of course, and not the so-called real economic value that is defined in the 2009 impaired asset communication as the transfer value reflecting the underlying long-term economic value basis of cash flows in a broader time horizons. So to this regard, it is our opinion that this constraint that is posed to asset management companies is highly problematic since the very definition of REV is somehow out of date and should be rethought. In fact, it basically implies that the standard market should be short-termist, which is indeed the case in reality. But this is in apparent contrast with the new, let's say, market sentiment, and also with the paradigm that the EU is trying to develop through the Sustainable Finance Action Plan. So the question arises, why shouldn't a private investor that is oriented towards sustainable investment pay out real economic value, and so that the benchmark of the public AMC should be construed around that criterion? Indeed, taking into consideration the supplier interest in a long-term perspective, where the suppliers here are the banks, is one key element of ESG factors. This being said, now we have to ask ourselves how the pandemic outbreak will affect the current ecosystem. Well, it's easy to say that when pandemic-related public guarantee schemes and payment deferrals that have been used by national governments will come to an end, it is quite reasonable to expect a robust build-up of new NPLs, which reasonably, arguably, would have an impact on the price equilibrium in the market, in the sense of a further depreciation of NPLs market price. In this respect, reading the NPL action plan by the European Commission, the boundary set in that action plan is that public schemes should be either no aid, as they are, or they should be embedded in a precautionary recapitalization under Article 32. But against this, the most important issue to be considered is that no aid public measures, including asset management companies' restraints on pricing, had a limited effect before the pandemic outbreak. So it is at the very least unlikely that they will be able to remediate the effect of a new wave of NPLs and its impact on price equilibrium. So I come quickly to our proposals. The first one is relating to the setting up of a regulatory framework at the UL level for loan participation funds that stems from the consideration that these vehicles are more flexible than other vehicles when operating on secondary markets, because they are excluded from the very core of potential regulations. Nevertheless, a limit to the growth of these markets lies, at least a growth of an internal EU level market, lies in the existence of diverging national regulation that cannot support an EU level internal market. So we advocate for harmonization, at least in the following areas that are here listed, that is rules to origination funds, common criteria with reference to the authorization regime under the Alternative Investment Fund Manager Directive, rules on the activities that these credit funds can carry out, and investment thresholds, reporting requirement, and the outsourcing of functions with specific reference to credit risk, as well as some flexibility that is now not present in national regulation about the leverage and maturity of these funds. The second proposal is to basically embed the governance of the resilience and recovery facility, and more in general public policies relating to the recovery of the European Union to the NPL strategy. So basically this would mean direct state aids to debtors through deferral and renegotiation schemes that should be different according to the nature of the debtor and the level of the deterioration of the credit. So large corporates in order to support corporate turnarounds, small corporates in order to support debt rollovers, and defaulted households or SMEs in a perspective of social inclusion. And this would, of course, as I already said before, indirectly benefit originators, because the eligibility of a debtor for state aid would itself raise the impaired asset market price. So now we come to the third proposals, which is in the spotlight, because it has been under discussion for some years now and becomes a hot topic in the last year or so. That is the one relating to the so-called European level bad bank. And to that purpose, I leave the floor now to Concetta. Concetta.
Thank you. Thank you, Ugo. Thank you to the organizer of the conference, my colleagues at EBI and the SRB hosting this conference. I go very quickly because I know that we are run out of time. As Ugo already explained in the start of this presentation, we believe that an asset management company, in particularly publicly funded at the European Union level, could be a very useful tool to foster an efficient secondary market for NPLs. Not a miracle solution, of course, not a magic wand, but a very useful tool that will facilitate the cleanup of banks' balance sheets following the wide increase in NPLs due to the COVID-19 crisis. Nonetheless, in the current legal framework, there are some obstacles for the implementation of such an ambitious project. The main is represented by Article 32, paragraph 4D of the BRD. Indeed, this rule provides that bank receiving an extraordinary public financial support should be put into resolution. According to the European Commission in the AMC blueprint published in 2018, this rule applies also to the case of an AMC publicly funded at the European level. We believe there are good reasons to exclude the application of this rule in the case at hand due to the letter of the law and after a careful reading of the rule within the wider regulatory framework. I should premise, we do not challenge this rule as it is. We think that it doesn't apply to the case at hand. According to the letter of the law, two conditions should be met to put into resolution a bank receiving a public aid. The financial support is qualified as state aid, regardless if it is provided by a member state or if it is provided at a supranational level. And the second condition is that the public support is provided in order to preserve or restore the viability, liquidity, or solvency of an institution. Ugo already explained that when the state aid to meet the first condition, then according to the European Commission, it does not constitute state aid if the public intervention respects the market economy investor principle. Namely, if a member state intervenes as a private investor would do and is remunerated for the risk assumed in a way a private investor would have accepted. The transfer of the price. It depends on the transfer of the price. And we have very positive experiences in Europe. Nevertheless, we believe that also in the case the transfer price from the bank's balance sheet to the AMC is the real economic value as described by Ugo previously, then according to the European Commission, we are dealing with a state aid. Article 32 of the BRD does not apply, because the second condition provided for by the law is not met. The AMC established as a tool to facilitate the proper functioning of the NPLs market normally buys loans from an indeterminate number of banks and do not only purchase credits from a single credit institution. That is the case described in Article 32. Furthermore, the public support is not provided to preserve or restore the viability, liquidity, or solvency of an institution. The goal of the public aid is to address the intertemporally pricing problem by overcoming market illiquidity issues. Are we proposing, there is a question, proposing to circumvent the strict provision contained in Article 32? May you go on with the slides, sorry. In Article 32, the answer is no. we are not challenging this rule because we think that the aim of this rule is to avoid the bailout of a troubled bank without putting this bank into resolution. And this principle, of course, is not challenged by our proposal. We think that is, from a technical point of view, possible to rule out the possibility that a bank insolvent or close to insolvency to access this asset relief program carried out by an European Union level AMC. And so we do not propose to circumvent this rule, but simply that the case we are discussing does not follow under the scope of this rule. There are also good reasons, if we read other good reasons, if we read the wider regulatory framework to affirm that this rule does not apply in the case at hand. I would like to draw your attention on the fact that Article 107 of the treaty confers broad discretion to the Commission to assess if under certain conditions and where the public aid does not adversely affect the trading condition to an extent contrary to the common interest, it could be considered as compatible with the internal market. Article 32 is not consistent with this treaty approach, in our opinion, tying the hands of the Commission. Indeed, even if the European Commission considers that in the case at hand, there are good reasons, especially in the context of the coronavirus crisis, for which the Commission has approved the temporary framework, to consider an asset relief program carried out by an MC publicly funded at European level in particular, compatible with the common market, it could not achieve any useful result because all the banks transferring impaired asset to a publicly supported AMC at no market price would have to be put into resolution or liquidation. A last good reason to exclude the application of this article is that the most relevant exception to resolution provided for by this rule is the precautionary recapitalization, where some conditions are met. Is precautionary recapitalization, as it is currently envisaged by the BRD, the right tool to deal with the NPLs in the scenario of pandemic? In our opinion, the answer is again no, because first, precautionary capitalization tool is tailored to deal with a specific situation of a bank. Secondly, precautionary recapitalization should not be used to offset losses that the institution has incurred or is likely to incur in the near future. The above conditions are hardly found in the case of a bank transferring NPLs to an MC, mainly because, let me say, pandemic and the resulting increase in the level of banks' NPL was, of course, an unexpected event, not due to bank errors or moral hazard. But at the time the transfer of NPLs from banks' balance sheets to an MC will take place, losses to offset have been incurred or are likely to incur in the bank balance sheets. This is another good reason to exclude the application of this rule to the case at hand, an asset relief program carried out by an European Union level AMC. And let me just to conclude this presentation. We believe that coronavirus requires a collective action, not only on the health protection side, but also on the economic and financial stability side. For this reason, we believe that all the useful tools, we don't believe that this AMC is a magic wand to solve any problem, but we believe that we need all the useful tools that should be put in place using maximum discretion to make them effective. Thank you for your attention. And thank you also for Bostian having accepted to comment. We are very happy to have your comments and suggestions. Thank you.
Thank you, Concetta and Ugo. That was terrific. 3 proposals on the table. We look forward to Bostian to having your views on this. The reality check.
Thank you, Georg, and then of course thank you, Concetta and Ugo, and of course Filippo and Antonella for a very interesting paper, which somehow defies the common saying and then somehow an apologetic view on this time is different in order to claiming that we are better prepared to deal with this financial crisis in this respect, which in my view is heavily used to appease, mollify, and soothe the unbearable feeling of unknown, what will really happen. And in this respect, this paper really brings a different perspective, which in my view correctly identifies the problem that European banks are facing today, namely the growing volume of NPLs. At the time, while we still deal with the legacy issues from the last financial crisis, and that's why some of us know that there have been attempts to differentiate between stocks and flows of NPLs. Stocks being a reflection of the last financial crisis, flows being somehow the outcome of what is happening here. So for me, the paper in this respect should be considered as a valuable addition to identification of the problem that might be looming around the corner. So what the paper really say? The paper tries to address this unknown in a steadfastly way, namely that once we get rid of all the forbearances, government moratoriums, and any other government help in order to fight off the effects of the pandemic, banks, European banks, might be faced with unbearable amounts and values of NPLs, which might cause yet another round of financial crisis. Though, if you remember last year at the beginning of the pandemic, everybody was saying that the banks were part of the solution this time. Now, after a year of being in a pandemic, we are somehow changing the narrative. It is all of a sudden the increased caution on where the banks really are, and this is where paper brings the contribution to a discussion on this very important issue. So, how the paper say what wants to say? First, by providing the scan evidence from previous crises, namely the NPL issues and then the ways that the NPLs were dealt with after the great financial crisis 10, 12, 13 years ago, through the introduction of asset management companies, special purpose vehicles, and in a way using this to illustrate two strengths of potential reasons why the asset management companies exist in a way that we know them. First, of course, through explaining the regulatory constraints in dealing with the NPLs, and of course in a paper. Paper provides a solution or attempt to address those regulatory constraints in rather handy and straightforward way, and of course with the market failures that brought us into the discussion of dealing with the NPLs. So In this way, paper also nicely identifies the bypasses, the potential and existing bypasses to regulatory framework that exists today, namely by carefully explaining the precautionary recapitalizations, issues and the misuse of something that is called market economy investor principles, which in my view is just a very lame excuse of not leaving the bank to face the real constraints and still a vehicle to misuse the public funds at the point when the bank does hit the wall. And of course, all other actions which are nicely grouped and defined in Article 32 for D of the BRRD and called these extraordinary public financial supports, which are drawing more and more attention today because it is clear to everyone that the pandemic now might be used to address the issues in the banks that would have issues already without the pandemic effects there. So there is this very blurred line. What is the pandemic effects and what is the effect of just mismanagement and all other issues of the banks that should somehow exit market. So the problem through identification of all these issues, the authors then come to the point that it is really interesting, and it is of course on the table today. So how to deal with the NPLs, and they find a way through this alternative investment fund manager directives in identification of loan participation funds that might be used and then somehow supported in a way to increase the competition that by authors' view today it's presented only by the investment funds, and in this way presents the in my view oligopolistic market condition. They're not oligopolistic. So I think that maybe my reading of what is oligopolistic and oligopolistic is wrong, but at least my reading of the textbooks is that when you have a single buyer, you have the oligopolistic market structure, and then when you have only one seller, you have the oligopolistic. But we have here the case. If my reading of what you want to convey is right, then we have two buyers for many. So I guess that you have to change that into oligopolistic. So so you introduce through this the directive, alternative investment fund managers directives, you nicely introduce the loan participation funds as the way of increasing the competition. Also nicely pointing out to the problem of real economic value there, but with legalistic explanation of why that is a problem. However, the conclusions then bring a really nice proposals. However, rather surreal when you take the political aspect into the whole story, and then of course the big unanswered questions: who would finance your solutions there and your proposals? So three conclusions. First is that yes, you provide a regulatory framework for bigger involvement of loan participation funds there, by claiming that those loan participation funds might be more flexible than any other vehicles, which is nice, but of course lacks any arguments why this might be so, apart from very legalistic explanations, and which is good for the reference point in explaining why this is so. Second proposal is really nice. I mean, this is directly state aid to borrowers instead to the banks. But then again, the question is who would finance that, and how would that be politically feasible? Of course, we might get to the situation that politicians might again revert and defy what they were so proud of claiming 10 years ago. No public funds for banks anymore, and now instead of eating up their own words, there might be a way to grant the state aid to the borrowers. But this is of course something that I'm not even willing to delve into it, and it is of course very nice proposal, but it needs to be taken in this political perspective. And then of course the third proposal, this asset relief program carried out by a European asset management company, where again I find it nice, but then the question that is still a little bit difficult for me to fully comprehend is how would you convince everyone that there will be not European-wide mutualization of the potential aid through these vehicles? I mean, I understand that the asset management companies on a national basis may do the job, but then you put all those AMCs on a national level, and then again we have 90 different regimes trying to put this together. And this is also something that in a general level we might have another conference and really ask ourselves, do we really have the European banking sector, or do we have 19 national banking sector attempting to be something, attempting to use the full meaning of objective European? So what are the main takeaways from the paper? Now, paper specific, I'm done in 3 minutes. Paper specific, 4. Presentation is much better structured than paper itself. So it's a pity. I mean, the paper, go and work back from the presentation and then include the conclusions in the paper, and you'll be better read and better understood. Second point, I guess you're wrong on claiming that there is a oligopolistic market structure, while I believe that it's oligopolistic. But maybe there is some expert here in the audience to help us clarify this. Third point, I do not really agree with you that the NPLs might hinder any implementation of the resolution strategy. Resolution, when bank hits the wall, doesn't really matter why it hits the wall. I mean, then you do the resolution strategy. So NPLs are just part of the bigger problem. So singling out NPLs and saying that NPLs might be the hindrance toward the implementation of the resolution strategy might be, but not as clearly and then bluntly stated as your conclusion. This is one thing. Second, and then the fourth paper-specific conclusion. I do not really fully agree with your analysis on the price compression of the NPLs. When you have the NPLs, you're doomed already. I mean, then the only thing is you want to offload the NPLs as quickly as possible, but of course under one and then single condition, that you have enough capital that you can do it. And most banks do not have enough capital to offload the NPLs, and that's why we have some banks that some might even call the zombie banks already. And this is a problem, and in some countries more pronounced than in the others. So, but we can discuss this separately. Now, on a very general take. The paper brings the value added to the very nice exploration on the regulatory frameworks, where you identify loan participation funds as a convenient vehicle for potential help in dealing with the NPLs as identified buyers of the NPL. This is really nice, and I think that your summary of the legislative framework across the countries provides a value value added for the reasons that others might find a good motivation to read your paper. Second, I think that you are pointing out to the state aid, but you never really make the point that however you get the state aid into the story, it's a state aid. It is a public money, and it is something that either you use it directly to the banks or to the borrowers. It is always a state aid and public money, and you need to resolve this in a way to bring it. Third point, secondary market, yes, but again, too much administrative support might create yet another bureaucratic blunder there. So for that reason, I think that you're correctly pointing out to the NPLs and to the request for making the NPLs market more homogeneous. We had the perfect opportunity in 2014 when we did Europe-wide asset quality reviews to make the market a bit more homogeneous. But I would hardly find anyone today who dares to do the AQRs today in Europe, Europe-wide, to make the NPL market more homogeneous. But again, it's worth doing it. But why? Because of course AQRs might reveal a bit unpleasant situation in the bank. So the also point on the secondary market and setting up the European-wide AMC, who would finance that? I mean, you have to find somebody who would finance that, and that is something that nobody wants to provide any answers to. Then the last 2 points, of course. Question of NPL valuation, their price. Unfortunately, if we talk about market, then there is a market. We always will end up with complaints that NPLs are below the real values or market values. This is so, and this is where the market solvency, bank solvency, becomes really important. So it is only for few that can afford to deal with the NPLs. For the others, of course, we're doomed to have the zombie banks. And then the last point. Why? I mean, I'm in this minority camp of the ones who claim that not single banks should be resolved either through resolution or liquidation.
I mean, sorry to interrupt, but we really need to conclude the session. Yes. Could I just ask you to wrap up, please?
Yes. So I am in the camp who believes that no single bank should be resolved either through resolution or liquidation. So we have overbanked European banking system. We should not waste a crisis to clean up the banking system. I know that this is a bit heretic, but and that's why I said that I'm minority there, and I'm just always very skeptical to any proposals to bypass the reality that might anyhow face us during this crisis. Thank you.
Thank you very much for this very detailed and rich discussion. Just listening to you, I think you could have continued, all three of you could have continued this discussion for hours. I just remind you of Elke König's comment this morning when she introduced the topic. She just said on this subject that there is no miracle solution, right? And that seems to be the very gist of solving that particular problem. I'm sorry that we are running a little late, so we don't really have a lot of time for discussion. I just wanted to bring in Christos Gortsos, our colleague from the EBI, who wanted to comment on your presentation. Christos, would you like to come in?
Thank you very much, Georg. Can you hear me? Yeah. Yes. And thanks to all the speakers and those who intervened. I think that was a great discussion up to now. My question, mainly to Antonella, is the following. Let's go a little bit into the ecosystem of the asset management companies themselves, yeah? And my question is relating to an issue which has come up again and again with regard to the performance drivers of these asset management companies. What are their policies, how they manage to get the loans, under what conditions, potentially in certain cases to the detriment of banks, in other cases applying very aggressive policies in order to collect funds. So in that sense, the new framework which is being shaped up, either that this will be with national asset management companies or with a network of that, or potentially with a pan-European, how should, from an institutional point of view, all these concerns regarding the performance of asset management companies be discussed and settled by the regulators?
If I can just add, because there were lots of questions in the chat. I'm sorry we don't have time to discuss all of them, but lots of questions asked about the design and the reality check, basically, and particularly the financing of those asset management companies. And this is basically something that Bastian also discussed in his comment, right? So maybe Antonella, Concetta, or Ugo, you 2 minutes to wrap this whole thing up, maybe, and then we need to move forward. Sorry.
Just 1 minute, or Filippo? Or...
Well, no, just one thing. Obviously, I handled the part of the paper on credit funds, and naturally there, the issue of financing is in the hands of the market. So we looked at that as a true market alternative to the other instruments for handling NPLs. But also we pointed out that we do need to take regulation into our hands and to harmonize what's been going on over the past few years, where some member states have set out rules which are different from others. So we need to build a European dimension, and this might help both in terms of NPL secondary markets, but also the issue of financing can be sort of supported by the development of credit funds, because those are truly secondary market instruments on both sides, collecting resources and using them for the creation of a more efficient secondary market.
Antonella, one word for you.
If I may add something with reference to the financing issue, the second proposal, the one that relates to the use of the resilience facility, I mean, of course, it comes with a cost, but the point is not resorting to additional resources, but to conceive the allocation of these resources in a way that is consistent with this political objective. And with reference to the EU level asset management company, I think that the correct question should be in terms of a comparative assessment of the cost that would be supported by the public finance now in order to have an asset relief program that takes place when the situation of the banking system is not so close to a risk for one or more banks, then when it will come the moment to address some resolution, some failure of the bank. And in this case, I mean, we do not have a track record that we can be optimistic about with reference to resolutions.
Okay, great. Thank you so much for this very interesting, thought-provoking discussion. I think, you know, this is really the prime example of research that makes concrete proposals and then gets a vivid discussion by some practitioners and policymakers, and the perfect research at the intersection between academic research and practitioner conference. So thanks everybody, thanks the authors, and thanks Bastian for commenting. That concludes our panel discussion on NPLs, and I'm just checking my watch. It's 16:04 now. I think we still deserve a quick break now before we enter into the panel discussion. So let's take a break of 5 minutes. Please come back at 16:10 Central European time, and we'll move to our panel discussion, which is entitled Lessons from COVID for Future White Swan Events. So lifting our perspective to the broader questions of COVID and lawmaking. Thanks so much, and see you all in a minute. Thank you. Okay, I think we should come back. Can I invite all the panelists to switch on their video screens? Franklin, are you there? Andrew Metric, yes. Franklin, are you there?
Yes, I'm here. Sorry, let me just get unmuted and start the video.
Excellent, thank you. All right, so now it's time for our panel discussion, which will conclude today's conference. And the opportunity here is to widen the scope beyond the, you may say, nitty-gritty of the technical bank resolution framework and look at the impact of COVID, not just on resolution or banking stability, but more broadly at policy conclusions that we might derive from such a pandemic, such a disaster, we must say. And we've entitled this a little provocatively as Lessons from COVID for Future White Swan Events. That sort of presupposes, first of all, that it is a white swan event, something that we already had a brief discussion about this morning. And the question is then, are we paying enough attention to likely non-financial risks in basically the way we design our societies, the way we organize our regulatory system, and of course, specifically on the banking sector in all of these. Now, we have an excellent panel. Very fortunate that you could all join us. Let me just introduce the four panelists in the way they will be speaking. So first we'll hear from Andrew Metric, who's the Janet Yellen Professor of Finance and Management at the Yale School of Management. And as a footnote, Andrew, I was intrigued to see somebody with a chair that is named after the current Treasury Secretary. That's a first for me, but really nice. Welcome to this event. The second speaker is Rosa Maria Lastra, who is the Sir John Lubbock Chair in Banking Law at Queen Mary University of London, and also a board member of the EBI. Great to have you with us, Rosa. And then you see Christos Gortsas on the panel, who has already spoken before. Christos is the chair of the academic board of the EBI, and in other things that he's doing, he's a professor of law at the National and Kapodistrian University of Athens. Finally, last but not least, we are delighted to have Franklin Allen with us. He is a professor of finance and economics at Imperial College London and directs the Brevin Howard Center at Imperial College. So you see we have lawyers and economists with us, and they are all discussing a question which is maybe neither legal nor economic, but rather maybe political, almost philosophical, of how to handle such challenging risks in the way we organize our societies. Each of you has 5 minutes to kick us off, and first over to you, Andrew.
Thank you very much, and thank you for the invitation to this wonderful conference. So I guess I'm going to talk about a little bit of white swans and black swans, so a variety of colors of swans. And certainly the answer to the question that is posed for this panel, are we paying enough attention, is most certainly no, we are not paying enough attention to it. And the primary thing I believe we should be doing to pay more attention to it is incorporating these non-financial events into our stress tests. We now have a mechanism for thinking about what the world will look like after a stress event of some kind. The one place that has gotten a fair amount of attention, although everyone's still worried about it, is a cyber risk. But I actually think cyber risks are temporary dislocations as opposed to things like what we've seen in COVID, and certainly we need to be thinking about various types of pandemic risks, but also climate. Climate is not just a long-term thing. The concern about climate risks is that we will have an event that will suddenly kind of change people's expectations. You know, a big, huge chunk of the ice shelf will fall off, or we'll have a horrible set of storms, some very bad damage due to water levels rising. Something like that will happen, and expectations will change very fast, and real estate valuations will change very fast. And we really need to be fooling around with these things in our stress tests to see what would be happening to the financial system, both on the capital side and on the liquidity side. There's no question that the muscular response to COVID-19, to the early days of COVID-19, was appropriate, but there was also a tremendous amount of flailing around and waste in some of that response, and it would be good to think about some of these things in advance. Now, more broadly speaking, we should be, and this is maybe moving a little from white swans to black swans, but black swans that might be white, and we don't really think about it enough, which is almost every year when we do the stress test, we should also be trying to imagine some version of the zombie apocalypse. What's the thing we're not thinking about, and how would it affect the financial system? And let's kind of run it through these models that we've spent so much time building. So that's my first point. My second point, second and final point, so I will stop after 5 minutes, is that we've yet to finish all our evaluations of all the programs that were done under COVID, but certainly for non-financial things like COVID, I think we should be worried about moral hazard even less than we should be worried about it in panic crisis times that are caused by financial reasons. And that is not at all. I don't think that firms are going to change their behavior a whole lot, knowing that the government stands ready to help them if we have a zombie apocalypse, that the government stands ready to help them if we have sunspots that disrupt our weather patterns. This is not going to affect firm behavior. This is not the kind of thing that Franklin Allen in his corporate finance classes teaches students, that you take this into account, that the government will be there in a zombie apocalypse. So we shouldn't be worried about it when we're designing our programs in these crisis times when they're coming from non-financial risks. We wasted a lot of time on a variety of programs worried about this in the early days that just never managed to get off the ground. So those are my 2 points to start, and I look forward to the discussion.
Cool, thank you. And that was spot on. Over to you, Rosa.
Thank you very much. Can you hear me well?
Perfectly.
Okay, I'd like to start by thanking the Single Resolution Board for organizing this conference with the European Banking Institute, and of course to you, Georg, as well as Christos, for inviting me. Yes, I agree that we must pay increasing attention to non-financial risks, though of course pandemics like COVID also translate into financial risks. We also observed in March 2020, when the central banks took, again, unprecedented action, and we can also see with the ongoing debt vulnerabilities in many emerging economies, something which of course we don't have time to talk today, but is a very important issue. And the responses to COVID, for example, directing unemployment benefits to workers, soft loans to small and medium-sized businesses, and bailouts to the most vulnerable big corporations such as airlines, have very important effects translated into fiscal and monetary policies. Some of the non-performing loan problems were discussed in the previous section. So again, there's a translation of non-financial into financial. Just very briefly, since we only have 5 minutes, I want to talk not about white swans, but also again about black swans and mostly green swans. So we all know that the idea of black swans was formulated by Taleb in what now is a very cited book, his 2007 book on the black swan and the impact of the highly improbable, and that being, of course, a black swan, an event that comes as a surprise and has potentially severe consequences. The pandemic clearly has those severe consequences in public health, economic dislocation, excess mortality, panic, and so many other things that we are all suffering. I myself went through COVID recently, so I know that this is not something this is a major problem for us all. But before the pandemic, people were repeatedly warned about the risk of a contagious new virus. And also we've been repeatedly warned about other catastrophic events, and the events triggered by climate change has just been mentioned. So this leads me from black swans to green swans. So here, this is not my own denomination, though, I mean, I guess in the new year, everything is green, green finance, green future. But Elkington, he coined the term green swans as opposed to black swans, and he refers to green swans as trajectories and developments that will take us to where we do want to go and deliver growth in the form of economic, social, and environmental wealth. And he kind of sees COVID as a potential for a game changer in how we can transform the way that markets are governed and also build more resilience for people and the planet. So the name of the game, as I said before, is these days green finance. I mean, if we look at the way that investment is taking place these days, it's clear that ESG has become fundamental, has gone from being one perhaps side way of investing to being probably the guiding force of investment in sovereign wealth funds and many other private funds in years to come. So trends such as impact investment, net zero emissions, climate stress testing, which was referred before, renewables, electric transport, sustainability in food, clothes, and others are here to stay. I can see from my own children and younger generations the attraction of ESG. From David Attenborough fight on plastic in oceans to Greta Thunberg's strikes, politicians have been forced to act on climate change, and this commitment to a new agenda perhaps is not just out of a common sense or collective sense of responsibility, and we can say ethical compromise with future generation, kind of intergenerational equity, but it's also a matter of enlightened self-interest. We do not want to retire in a world of social unrest, insufficient water, or extreme weather due to climate change from unethical investments, for example. Today there was an article that the IMF published on the COVID's long shadow, the social repercussions of pandemics. This is again all part of ESG. The second point I want to touch very briefly, conscious that time goes away very fast, is that central bank mandates obviously are responding now to the sustainability and climate change. And given that time is precious, I will leave away the Bank of England and the Fed and focus just very briefly on the ECB. The ECB, as we all know, is in the midst of a profound exercise, a strategy review, the first since 2003, and according to President Madame Christine Lagarde, we should leave no stone unturned. So one of the things, of course, that is a great concern to the ECB mandate and also to accountability in the European Union generally, is that notwithstanding the primacy of price stability, and again, I'm not going to discuss that today because we're talking about non-financial risks, but the ECB is also mandated to support the general economic policies of the Union. And these are actually understood in a very broad sense, not just employment and growth, which is sufficiently large, but also the quality of the environment and the broader goals of sustainability and solidarity, which reminds us of the social agenda. So this is, I think, a major challenge for the ECB, both as monetary authority and also supervisor. Again, a stress test can take into account green finance. I must say a note of caution. The ECB, in my opinion, should not engage in selective credit allocation. I have never favored credit allocation, so it should never favor some industries or companies over others by buying their bonds, some green bonds. But that's perhaps a debate for the Q&A. And the final point, very briefly, I know that I'm just running out of time. I would like to talk perhaps a little bit more about accountability in terms of actions that impact upon climate change and pandemics, such as the liquidity assistance of the ECB and how that can be used for other areas in which we are concerned about the non-financial risk. But I wanted to mention, just completely out of the blue, almost like a philosophical question, something that we are all experiencing just by the way that we are conducting this interview. We all live in Zoomland. I'm conscious that today is WebEx, but we have been conducting our education and our work life on a screen for almost now, soon to be 1 year, really, since March. And this actually puts us a very big economic and non-financial question, which is the need divide between home and office and the impact of technology. So I would encourage all of us to have more multidisciplinary studies drawing on law, economics, anthropology, philosophy, psychology, even nutrition, architecture, medicine, to cater for the needs of individuals, families, and communities in this not so neat divide between the home and the work and the office. And obviously, the impact of technology in all of this is a fundamental game changer that has, I think, put the economy and put the financial system and put our social system on a new level that we are here to stay. We're not going to go back to the world that we have pre the pandemic. So I think I apologize. I think that was 7 minutes. I try my best to summarize these 3 points, but I will now leave the floor. Thanks a lot.
Thank you. 7 minutes, very worth listening to you. Thank you so much for these. And I'm glad to have you fully recovered here and in full shape. Thank you, Olga. Now, Christos, we've heard about white and black and green swans. I wonder what color you will bring into the debate.
I have only seen white swans in my life, so I cannot discuss about green or any other swans. But by the way, before asking whether we pay enough attention to non-financial risks, I think we should for a moment consider whether we are really paying full attention to financial risks. And my understanding has been that for a long time, this aspect has also been neglected. It's not in our days, but just to remind to all of us that potentially the global financial crisis of 2007-2009 may have been due to several aspects, including to the fact that some risks, some shocks have been underestimated. And since I have heard about Taleb, I think for some time he was at Wharton, and I know that Andrew was at Wharton, and of course Franklin was professor at Wharton. I would recall another famous Whartonite, two of them, Richard Herring and Jack Gutentag, who had written back in the 80s a paper on disaster myopia, another Greek work, like monopoly and monopsony. Here we have myopia, blindness in international banking. And I would like to generalize a little bit on this, because I do believe that apart from whether we pay attention to non-financial risks, financial risks altogether, I would fully agree with what I heard before from Andrew, that including them in stress testing would make sense. I would like to go into some perceptual, cognitive issues, concerning how we address and how we position ourselves against risks. And in that sense, if you allow me, I would distinguish between those risks which have a high frequency of happening, like, for example, credit risk, and other risks which are of more lower frequency, but then when appearing and when materializing, the losses out of them might be huge. And in that sense, I could believe that the environmental risk, for example, might be one of these cases. We have not paid enough attention and potentially not measured them, not mitigating the risks coming out of them, but eventually a major the manifestation of a major environmental risk might create such losses, not only for the banking sector or the financial system, but for the economy. And in that sense, I would like to raise two issues. The one, we usually refer to a lot of legal frameworks and rules as children of crisis. That means that it usually takes a crisis in order to adopt measures which could have been adopted previously, and in this case, eventually, the extent of the shock, the extent of the crisis might have been less. And I think that a notable example of that is the macro-prudential frameworks. Yeah, I remember it was as early as in 2000 that a lot of scholars, but also policymakers, I remember people at the BIS, I don't want to name them, they have been writing about the need for the existence of macroprudential oversight and macroprudential rules and buffers. And then it took a crisis, a huge crisis, in order to implement these measures. And this is part of what I would label as the persistence of a disaster myopia. Yeah, you believe that the risk will not materialize, even if you have some signs of this. You don't take the measures, and then only after the shock has taken place, you take these measures. And a second point that I would like to add to this is the following. Disaster myopia, or the tendency to underestimate risks, is not only with us individuals, it's not only with businesses, including banks, it's sometimes with policymakers, it is with regulators, it is with supervisors. I hope not with resolution authorities, since we are co-hosting this with the Single Resolution Board. I would exclude them from the big picture. But again, the means that in some cases the reaction of policymakers and of businesses as well has not been as appropriate and not timely. So by concluding, I would wish that the whole perception vis-a-vis low frequency risks would be different, instead of simply differentiating between financial and non-financial risks. I think that the roots of the problem are deeper, and it is on this that one might wish to pay more attention. Thank you very much, Georg. I hope it was not more than my 5 minutes. Yeah.
Perfect. Thank you, Christos. If we follow your point, that we would wish for a very big crisis, right, that gives rise to new activities in the future. So never waste the crisis, right, for doing something. Anyhow, Franklin, you have the final word.
Thank you. I'd like to thank the organizers for inviting me to this very interesting panel. Last year, we saw some of the biggest drops in GDP in many countries for a very long time. Now, there was a huge range of those. So one extreme, China actually managed to grow, but it was essentially the only large economy that managed to do that. At the other end of the spectrum, we have countries like the UK, where it seems GDP, when the final numbers come in, will have dropped by something like 10%. And that hasn't happened for over 300 years in the UK. So these are massive drops. Now, the response of governments has been to intervene and provide insurance on a massive scale. So they've provided loans to companies, they applied furlough schemes to keep workers' incomes high, many other kinds of schemes. And this has led to borrowing, which is unprecedented outside wartime. Now, one of the interesting things is, despite this massive recession, the financial sector hasn't been doing too badly. In fact, what we've seen is that financial markets are now, in many countries, doing better than they did a year ago before COVID-19 became a problem. So if you look at the S&P 500, it's up significantly from a year ago. Now, that's true in many bond markets too, that bond markets are doing fine. If you look at the banks don't seem to be in trouble. And the question is, well, what's happening? Well, unlike the great financial crisis, the way governments are financing this is not through austerity, or, as in many cases, through taxes in previous kinds of situations like this. What they're doing is they're essentially borrowing, but this isn't like borrowing for the world wars, for example, which was essentially international capital flows. They're borrowing from central banks, and the central banks are printing money. Now, the usual argument against that was, well, that's going to cause a lot of inflation. But we don't see that. what we see actually is many people seem to think deflation is a much bigger problem than inflation, because what's actually seems to be happening is that the money that they're printing is going into the financial sector, and people are saving it, they're investing it, and so on. They're not going out and spending it yet and causing consumer prices to rise. Now, the big question is, how does it unwind? Now, if you talk to macroeconomists, many of them believe, well, it'll be okay, because what will happen is the central banks will go out and they will sell the assets they currently have, the trillions of euros or dollars or whatever denomination of assets that they've got. That'll take the money out of the financial system and everything will go revert back to normal. And if that's the case, if 5 years from now that's what's happened, then this seems to be a very good way to deal with these kinds of problems, because you can provide the liquidity, you can provide the assistance, it isn't inflationary, and this seems a good way for society to operate. And I agree fully with what Andrew said. I don't think it's too much of a moral hazard problem. These are such low probability events, it's not a big deal. Now, the opposite view, which a number of people have, is that no, this is potentially disastrous. We're going to have huge inflation. We already see it in asset prices. It won't unwind. It's not going to be easy for the central banks to sell off these assets and get the money back in. So I think that's a very interesting dilemma we face. We have to wait and see, are we going to be affected by this in the long run, or is it going to be just an insurance event, which is very different from any kind of insurance event we've seen before? And in that case, I don't think we have to worry too much. If this is okay, it's not going to cause huge inflation, it's not going to lead to large amounts of taxes or whatever going forward, or austerity, then it seems to me we're going to be okay. But there's a big if there, which is it could all be disastrous, as many people think. So I think that's my 5 minutes, so let me stop there.
Thank you, Franklin. Terrific. So that was a nice, refreshing contrast, making the case that actually, you know, maybe it's not such a bad situation after all. So your response to the initial question would actually be no, right? We do not need to change our attitude dramatically in the way we regulate things.
Exactly. No, we seem to have discovered a way of providing insurance on a massive scale by government intervention. And at the moment, at least, we don't see too much in the way of costs for that.
Right. Good. So this is the moment to involve the audience. And I have already received a couple of questions, but can I encourage everybody to use the chat function if you have questions to the panelists? I'd like, when everybody is ready, let me just jump in myself and ask something to Andrew, you know, that picks up some of the issues that came up in the overall discussion here. That is that you said, you know, you might want to change bank stress tests in the future, or you might want to, you know, use any other tools of revisiting those sorts of problems and future regulation. It seems to me that, as Christos was saying, you know, the problem is that these things are frequently born by crisis, and they are necessarily backward looking, right? So what we might do now is sort of look at, oh gosh, right, when's the next pandemic coming along, or what's the next fix that we have to address a health problem? But then again, the next crisis in 10 years from now might be something so fundamentally different that it's impossible to predict with that backward looking perspective that we human beings somehow have, right? So what's your take on that? How could we be open-minded enough in order to capture all potential developments?
What I would say here is that actually, if you look at what some of the most effective early reactions were in the COVID crisis, they were largely very muscular reactions that restored liquidity to a variety of markets. And they were almost exact copies of things that we had done 10 years ago, right? Or 11 years ago at this, whatever it was. So even though the COVID crisis and the real estate bubble, safe asset glut shortage crisis of 12 years ago were totally different. Actually, the initial responses, which used those things, were phenomenally effective. So I think it is somewhat overblown, the idea that like just because we don't know exactly what the next crazy crisis will look like, we cannot sharpen our tools by thinking about things that are different than that. And in fact, it's a great success because it was quite unusual. We didn't make the same mistakes that we made 12 years ago. We made some new mistakes. That's great. That's progress, right? Often we're making the same mistakes when we're fighting crises that we've made before. And here we made some new ones because we hadn't really seen this type of situation before. The more things we experiment with in stress tests, the more likely that we will have touched upon something that looks vaguely similar to what's coming up soon. It's a lot like the vaccines and the virus. You know, the virus is going to mutate. We know that. We're not going to have complete protection. But if we look at things, if we look at various types of climate risks, yeah, they may not be exactly the same as a different type of thing that we didn't think of, but it may give us, oh, okay, well, what if a chunk of the world is shut down or underwater for a little while? How would we deal with that? That may give us some hints for how to deal with other things that come out. So I think we just need to not make the perfect the enemy of the good. And this has been a challenge for those of us who study past crises to try to guide the future. People are always saying, but the next crisis will be different. Of course. So does that mean we should learn nothing from the past? That's what I would say. Of course not. So let's keep learning. There were some great successes early in COVID, and the policymaking community should be very proud of those.
Thanks for that. I mean, I think I agree. It's just that you know, the learning process is great and well taken. It's just that we know that in 10, 15 years from now, memories of the pandemic will fade, right? And that will be the moment of deregulation. In the same way as we're seeing deregulation of any post-financial crisis right now happening to kick in, right? So the human being is quick in its attention span, and democratically elected politicians may shift their attitude to other things in the future, right? So the learning process, I agree, is necessarily good, right? But it might not necessarily endure in the future. Right?
Well, I agree that from the regulation side, from the way the population thinks about it, you know, they're not going to be focused on, certainly not the financial side of this in 10 or 15 years. But human civilization is built on preserving this knowledge, at least among the experts, not losing it. You know, we don't need a dark ages of how to combat a liquidity crisis. So let's keep this knowledge in conferences like this, in the places like the SRB and the ECB and the Fed, the BIS. They need to maintain this knowledge and make sure it gets passed on to the next generation of crisis fighters.
Oh, that sounds very great. Yeah. Any other panelists wishing to comment on this?
May I simply add to this? Yeah. Appropriate action, whatever that is, depends on two factors at least. The one on a very good set of information that we have, which will, as a matter of fact, guide the decision that we will take. And potentially, in our days, we have more information about these risks arising from the COVID. And the second is the willingness to take action. And sometimes it's on this second front that we are facing several problems. The inertia that I mentioned before. During this crisis, it has proved that decision taking and the actions taken were quite rapid. Yeah, they were prompt. But again, it is very questionable whether we will see in the course of the next 5 years a framework which will take all the lessons from this crisis into an appropriate policy system. And this is my concern.
Okay, let's pick some questions from the floor now. There's one question from someone called Mishadi. if you could comment on the future role of systemically important banks, and particularly the concept of ring fencing. So I guess it's the question about the stability of the banking sector, particularly, and the way we've ring fenced or separated markets over the last several years. Is that something, Rosa, that you might want to comment?
Yeah, I mean that's a purely a financial risk. So we go back from the subject of non-financial risk talking about financial risk. So I think that one of the biggest trends now, as everyone knows, in finance and particularly in banking markets, is kind of the disaggregation of the functions of banks, deposit taking, payments, and credit, and the new competition that comes via all the fintech different type of initiatives, as well as the major companies, the Googles and the Amazons, providing themselves via Apple Pay and via different innovations from Libra to others in entering into the mainstream of financial services. So in that sense, someone is perhaps must mute the
Yeah, somebody's typing.
Yes.
Maybe.
Anyway, so I'll just continue. So I think that there's a concern with the future of the systemically important banks and all the list of their various SIFIs and fighting the last war, something which obviously in regulation has happened in the past. And I think that the future role of systemically important banks, one of the things that we need to do as a matter of regulatory design, yes, of course, we need to learn the lessons, as it was saying by Franklin before, the lessons of 2007, 2009. We cannot have bailout programs again. We need to internalize the cost. That's why the Single Resolution Board came into existence, and we need to move from bailout to bail-in, and we need to ring-fence somehow the risk. I'm just trying to kind of put that question into a broader theme of whether the real challenge for the future of banking regulation actually lies elsewhere, lies in all the competition that comes from the non-regulated sector, from the various shadows that are actually becoming quite mainstream. I mean, clearly in countries like China, that's already the case. I teach a classic course on banking regulation, and my Chinese students keep on always reminding me that the importance of banks in China is not like the importance of banks in the EU. And clearly that is something in which, as a matter of regulatory design, we need to think with regard to the future role of the regulation that affects systemically important banks, whether or not we might be fighting the last war, and whether or not the classic concerns of protection of depositor confidence, prevention of bank runs, is kind of moving to other areas which are unregulated, and eventually the formal regulation will need to be applied to this informal sector. So rather than talking about ring fencing of deposits, are we having shadow deposits in which we're not protecting sufficiently the new instruments and the holders of those instruments? So perhaps a deviation from the question, but that is part of my research at the moment, and that's what came to mind when you asked me about the future role of the many families of SIPs and SIFIs. Thank you.
In that context, Franklin, is the current one actually a financial crisis? Will it be a financial crisis eventually, or is, as Rosa suggested, quite a different type of financial crisis maybe in the making with the rise of shadow banks and others?
So I think that's the interesting question, which we don't know the answer to. So is it a bubble? So how can the stock markets be better off than they were a year ago, when we've still, in many places, deep inside a health crisis? GDP is still down in many countries a significant amount. Does the future really look that great going forwad, so that to justify stock prices being significantly higher? Now, you can say it's the stimulus packages and so on. You have to wonder about the politics of all this too, because if the politicians think there's no need to tax people, to do all those kinds of things, that they can just go out and borrow And in most countries, borrowing costs have actually gone down despite the enormous increase in debt. So, if you think of the Eurozone, much of the debt is negative yield. So you don't have to actually worry about paying it back. You just wait until it goes away. So there are a lot of questions out there which are unanswered at the moment. We see the kind of GameStop frothiness. We see a lot of things which suggest that market infrastructure is going to come under significant pressure. And I think we still have a lot of uncertainty. I don't, just to say a couple of things, it's interesting how things are playing out in China. I would agree that up until the IPO scheduled date, that things were working very differently there, because in most European and in the US, the regulators protect to a large extent what happens in the shadow banking fintech sector. So they have to be small, and they don't let them take very large chunks yet of business away. But of course, Ant had the biggest money market fund in the world, and they did that essentially being allowed to do so by the regulators. But now the regulators have fought back, and I don't think that the fintech sector in China is going to be quite as innovative and threaten the banks as much. So I think going forward, things are going to be different. I think this magic money tree that we've got will change how we deal with things. So, there's no reason for banks to default in a crisis if you can print money and give it to the banks and they pay it out. So that's essentially, to a large extent, what's happening here. And I think that will change financial regulation and how we view financial crises going forward, because we're not going to be doing austerity for a while, I would say.
Terrific. No, we don't. And in history, actually, we've always found ways of getting rid of a huge debt pile, right? So that must be a way in the future. But I wanted to shift the discussion around these very interesting issues to a number of other things that came up in the question. I've had a number of questions now concerning GameStop, right? And of course, that question had to come. I think one nice way of putting it is here a question from Pierluigi Bavarisi saying, COVID was a gray swan and GameStop is the true black swan. So what is the view of the panel in how to anticipate risks like that? Or is it a risk, right? Is it maybe something that we shouldn't really worry about in Franklin's? Andrew.
So I as the token North American here on this panel, I'll comment a little on GameStop. As you might imagine, it's been a big topic of conversation here on our side of the ocean.
In Europe as well. So.
I have avoided commenting publicly so as to avoid being quoted and having the Reddit bros come and egg my house. So I have managed to avoid that so far. So all of this, I will deny that I've said any of this if anyone tells it to the Reddit bros. But so I mean there's a couple points with regards to financial stability, which is our topic here. I really do not think this is a big deal. I think it's a signal of some other frothiness and stuff that's around in the markets, but I think it's mostly a signal in this particular case that young men have a lot of time on their hands and are not feeling tremendously poor, and they're motivated. Part of this is a motivation for little class warfare, get back at the hedge fund, show them who's boss. It's like a video game to them. But from a financial stability perspective, if the entire long-short hedge fund industry were tomorrow to go out of business, the question for financial stability would just be, to what extent are the banks actually on the hook for that? Are they properly collateralized? If the core of the financial system, if the prime brokers have properly protected themselves, which usually they have, the reason the hedge funds in long short go out of business is because the prime brokers close them out of their positions when they don't believe their collateral is sufficient anymore. So this is mostly risk capital that is at risk. Stock markets can go up or down by trillions of dollars without it causing concern about the solvency of the core banking system, without it causing any liquidity. We see it happen all the time. They go up and down. You know, the dot-com crash was enormous, but there's no financial crisis that came out of it. So I'm not that worried about financial stability for that. My concern more, Franklin is right, that so far the financial system has done well, and it has in large part because the government has done a tremendous amount to prop it up. But we're now entering a place where it's not necessarily formal austerity, but just kind of running out of political space to do more things. And some of the things that are left on the table to do are places where we bring the banking system into the stimulus. So instead of GameStop, which I think is really a bit of a sideshow, you know, another issue is we have $3 trillion of commercial real estate on the books of United States banks, and we may very soon tell renters they don't have to pay. You know, someone is going to pay for that. Ultimately, that may land on commercial real estate. So that's the core of the banking system. That's places where I would then worry about the banking system's ability to manufacture the safe assets that go forward. And I think politically it will be quite difficult for governments to help banks directly. They can kind of help them the way they're doing it now, but directly will be tough. Capital will be tough. So GameStop, you know, I think it's a couple $100 billion is the whole long short hedge fund business. It's levered a couple times, but not that much because it's hard to lever your short side. And if they lose $1 trillion, you know, they lose $1 trillion. It's some Reddit bros feel a little poorer or richer if they win. And on the hedge fund side, might be some endowments, but it's largely not the core of the system. So anyway, that's my long, and I will deny it if anyone tells any of the Reddit bros that I said this.
Okay, we all witnesses. But you had a question to Andrew.
Yeah, just put it in the chat. So you don't think, Andrew, from what you said, that we will end up needing a private life rescue initiative such as in LTCM?
No, I mean, so the LTCM case was quite different in the sense that, so first of all, they were enormously levered. For the most part, the hedge funds who are battling this, you know, when you're a long short hedge fund, there's quite a limit on the leverage that you can put up, both from regulatory and just your prime broker putting limits on you. LTCM was levered enormously, and it was largely the core of the financial system that was on the hook for it. So to the extent that LTCM had collapsed, it was the various prime brokers and the people who would lend to them that were going to be in trouble. And so that's why the New York Fed was so concerned. This particular thing, things that involve, and it was bond markets, you know, they were very much involved in the same type of relative value strategies that the hedge funds in March and April were in trouble for, that we did need to help, right? But the long short equity funds are involved in some very different game. And generally, if it's just about the equity markets and derivatives on the equity markets, and you know, we could be wrong, but it's at least a full degree removed from the core of the banking system, where I would worry that we would suddenly need capital in the banks or liquidity for the banks.
Thank you.
Somebody's phone is ringing here, but sorry. Yes, okay, so that's excellent. I have one question from Chris Bates. I don't know, Chris, if you can speak yourself, or no, probably not. I'll read it out. So the question is probably addressed to Franklin. So Chris Bates is a partner with Clifford Chance in London, and the question is, central banks are ending up holding, in some cases, as much as half of the government's debts. What does this mean for financial stability and the recovery?
So I think that's what I was referring to in the question in the last part of what I was saying in the initial comments. How is this all going to unwind? So one view is they just keep them there, and the money stays in the financial system. We have people holding large amounts of savings and so on, And then over a long period of time, it gradually goes down and we get back to normal, but it'll take some time. Now, you could view what happened in the 19th century as being like that. So, at the end of Napoleonic Wars, the UK owed about 250% of GDP, and they paid it down over a long time. This is a bit different because the central bank's holding the debt, but essentially we could see a similar kind of process that over a long time you could chip away with it and not see a big effect, and things work out fine, that the economy goes back to normal in a few years, 2 or 3 years maybe, depending on the country. The banks don't get into trouble and everything's fine. Inflation stays around where it is at the moment or goes up to where the central banks would like it to be. And that could all work out fine. The alternative is that there's going to be a big splurge of spending when people get out of the lockdowns and so on, and prices are going to start going up, and then we're going to have to see the central banks do something about the inflation, and that can be problematic and can cause big problems for the banking system. So one of the big issues is, so how long should the debt you issue to deal with these problems be? And if it's long debt, suppose they issued perpetuities, then that's great in terms of low costs of borrowing, but it creates potentially financial stability problems because it's precisely long assets that will be affected most by significant changes in interest rates if inflation goes up and central banks start to fight it. So I would say there's just huge uncertainty from it's not going to matter much at all to we could be in real trouble and have big problems in the next decade or two as a result of this accumulation of government debts on central bank balance sheets.
Okay, but I think I take it that you generally stick to your rather optimistic.
Well, it depends which day you catch me. There are a lot of people that worry a great deal about potential inflation and so on, but they seem to be in the minority at the moment.
Right. Yeah, so we've heard a couple of views now, a couple of examples, ESG, GameStop, fighting COVID, and the panel has largely been rather optimistic. And I think one thing that I would like to put to all of you is the recent developments, that really particularly concern the European Union now, to move towards a common financial response, right? To build up some fiscal capacity at the EU level, which has been hailed, and sorry, Andrew, for hijacking the term, has been hailed by some as the true Hamilton moment in the EU, right? So first step towards some fiscal capacity at the EU level, which again is something that was unthinkable even 2 years ago. And is that sort of result, something that Christos, I think, referred to in his initial comments, the power of a crisis, looking into the abyss, and then, being able to agree on things which were unthinkable before. Is that the way forward, how we should see this crisis as an opportunity in that context? What is the view of maybe Christos, you want to comment on that?
No further comment. The common backstop, by the way, has been designed. You remember that, you know that. It's built within the possibility of setting up a common backstop. Was provided in the SRM regulation. And don't remember Article 74, something like that, at this region. Yeah. And then it took 5 years of discussions to come to a final solution for this. Yeah. And we all remember that it was discussed even within the framework of establishing a European Monetary Fund, a proposal for a regulation which has never been adopted. And then we're discussing about modifications to the ESM treaty. And finally, again, after the crisis, it has become evident that this backstop was necessary. And again, I would be critical, not with regard to the decision taken, but with regard to its implementation. The fiscal backstop will be there only in 2022. Yeah. So again, we have a kind of not recognition lag, but we have an adoption lag. Yeah, and these lags sometimes may create more hazards than necessary. But again, it's a bold way forward. Correct? Yeah.
No, sure. I mean, that's well taken, but still, the agreement is what matters, and the psychological step of joining forces now is, I think, the real moment, right? And you're right. I mean, there are many strings attached to it, and it's definitely not a true Hamilton moment because it's very limited and temporary. But still, that step is still, unimaginable.
And as a matter of fact, in my view at least, much more important than the creation of the European Deposit Insurance Scheme, for example. So if we have some leftovers from the completion of the banking union, this was, in my view, one of the most important, including the harmonization, referring to the first panel, yeah, of the rules concerning insolvency, potentially only for the banking sector or in general for companies in the European Union. But I think this was the major part of the unfinished agenda, and it is only with relief that this has been adopted. But again, a little bit too late, and potentially, if the case be that the amount of NPLs after the lifting of the moratoria will be significant, at least in some parts of this European Union, yeah, then the case may be that this will have to be activated sooner than in 2022. But let's hope that this will not be the case.
Good. I think that's a very nice optimistic note to draw this panel discussion to a close. It's been very, very stimulating to listen to all of you. Thank you so much for your different perspectives. We've covered an amazing ground, right, from green and white and black swans over GameStop and ECB funding, and I take away a rather optimistic ground note here in the panel that we will be able to learn from crisis, and maybe including with Franklin, it's not that bad after all, as long as we keep the rules of the game in place. But thank you so much for joining us and for your time in contributing this excellent panel. And I draw this panel discussion to a close. And at the same time, it's my great honor to say a few words to mark the end of this conference. I've seen a lot of people staying throughout the day. It's been exciting to have this great support from the audience. Thank you so much for joining us here today. And my takeaway from this entire day is really encapsulated in the acronym of ECB, not the ECB as an institution, but ECB as an acronym for experience and COVID and Brexit. I mean, these were the three major themes running through the day. Experience with resolution and banking stability that stems from the last crisis, which is still not so far away, just 12, 13 years of learning experience, but we have, and I think most interventions have made that clear, we've come a long way of making the system more resilient and more stable. We are see in COVID in the next crisis, and we've heard from this panel that we must keep on learning, and maybe we have understood the lesson. We know how to do it and to deal with such a problem in the next, and the stimulus that comes from the central bank seems to be working. So on the banking side, so we haven't really seen any major banking crisis developing at the same time. And finally, Brexit. I think the Brexit session this morning was also rather optimistic in its general attitude, because the risks, in particular to the banking sector, so far haven't really materialized yet. And if we continue this journey in this cooperative spirit, I think we'll be able to contain all of those risks. So with that rather optimistic note, I would like to close the conference and thank a number of people who have been involved in running and organizing all of it. Most importantly, in Christos Gautsos, who is my dear colleague and co-organizer of this conference. It's been wonderful to put this together, and you know, a nice event has come out of it. Thank you so much to our cooperation partner, the Single Resolution Board, and it's been wonderful, you know, speaking on behalf of the EBI, to do this event together with you. I think this type of event where we have academics and practitioners is really useful, at least speaking from our side, because it gives our academic ideas a reality check and a very fruitful discussion on many fronts. Let me single out in particular Susan Carroll and Sammy Harris, who have been wonderful in organizing this event, and also Etienne Dubois for the IT. So thanks to IT, you know, we managed to keep all of those risks under control, and we managed to see each other without traveling. It's been great to have people from near and from far here on the panel. We've had people from all over the globe. It's been great and stimulating discussion, and that's it. Thanks all speakers and discussants, and last but not least, the audience for coming in. And I hope it's been a good and fruitful day for all of you. Thank you so much. And I now hear normally a roaring applause from all sides, but in the absence of any physical meeting, thank you again. Thanks and have a good evening.